what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Hey, money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
How dare you!
Hey, good morning, good afternoon, good evening, everybody. Good night, wherever you are, whoever you are, whatever you're doing, whoever you're doing with and all that other stuff. I'm just glad you're doing it here with me. Legal Vices, we are on the go. It is time. We have a lot of ground to cover, and by a lot of ground to cover, I mean a lot of ground to cover. So, without further ado, as people in other places say, let me bring up Megan Fox real quick here. Howdy.
Sorry about my avatar. I'll get it fixed in a minute. I'm using the new StreamYard mobile app. So, whatever.
Oh, I did not know there was one. Ooh,
I didn't either, but I
right.
just noticed it said for a better guest experience, download the app. So I'm trying it, and it does seem a little bit easier. Can you hear me okay?
Perfecto.
Oh, wonderful.
All right, sorry for all this, because we had something planned and scheduled, then we didn't, then it was a maybe, now it's a go. So we threw this together at just about the fastest I've ever thrown a stream together before in my life. So here we are. Oh, look at that. That's nice. This is like way cool. Now I want to just like go offline computer and start using just a mobile app just so I can try it.
Yeah, it's That's great because awesome. I can actually see the comments, which I was not able to do before, and also I can chat. So this is great.
Perfecto. Awesome. That's awesome. Yeah. I'm glad you're here, Megan Fox.
I'm glad I'm here too. I'm doing chores. There's a lot to be done. So I'm mobiling around my house, but I definitely want to go over this with you. This 144-page motion, which has not hit the docket yet, you are getting it here exclusively. Nowhere else. Nobody else has this kind of access. So we've got it, and we're going to share it, and it is something else, you guys. It is. If you thought the motion for a new trial was bad, wait till you see this one.
Well, just to tell you how bad it is, we've already gone limited advertising on this. Already, we're yellow.
Are you serious?
Yes.
Why?
Because we're talking about sensitive subjects. That's why.
I guess.
What, so,
is the sensitive subject that Ethan Shapiro and Howard Hunter are a couple of twats? Is that the sensitive subject?
Well, that's not going to help when the YouTube personal reviewer comes on and hears you say that 4 minutes into it. She was just kidding, YouTube personal reviewer. We're not going to say that for at least another 5 minutes. Wow. When we say exclusive because she was saying this has not even dropped on the docket yet. Everything's been filed. It just hasn't worked its way through the system over the weekend yet. So we are good to go with this. Again, as Megan was saying, it's 144 pages. We're not going to do all 144 pages because it took us 4 hours to do, what was it, 39 pages?
40 pages, yeah. But you've been through it and you've highlighted a lot of the garbage, right?
I have. How much of it have you managed to get through? Because this is literally hot off the presses.
Really only a few pages. Like I know that page 60 is 59, I think, either 59 or 69 has a really unbelievable admission on it that I showed to you first, which is, I hope you highlighted that one, because that's the admission where they're saying that the locking her in the room for 48 hours was actually at the behest of Sally Smith and had no medical reason whatsoever. Well, that's what they said didn't happen. Throughout the entire trial, they said that that wasn't the case, that it had a medical purpose. Well, in this motion, they're admitting it didn't have a medical purpose and that Sally Smith wanted it, which was one of the reasons why they did it.
Oh, there's so much going on in this motion. And the thumbnail, it may be a little clickbaity, but not intentionally. When I say shocking new motions, I don't mean the motions themselves are shocking. These are very, very standard motions you make after you get your ass handed to you in a trial. It's the motion to set aside the verdict, the motion to reconsider the the motion for a directed verdict, reduced damages, to have a new trial because the judge made errors of law. These are all very standard motions you would make. What I find shocking is the language that they use in this motion, as well as some of the contents. But I mean,
is there any palpables? Are there palpables?
There are no palpables. But do not agree to take a drink every time you see an exclamation mark.
Oh no, I'm never drinking again. I'm never drinking again because I woke up with a headache like you can't believe after that. So no, I'm done for several months.
Well, see, this is what I was talking about yesterday with the motion. When you use this hyperbolic language, I think that's your last resort when you don't have anything factual or anything persuasive using normal, ordinary language, and you've got to go to the shocking, hyperbolic, italicized, bolded, underlined, exclamation mark kind of words. And it detracts because they say something. Is it really as bad as that word you used makes it sound? And I don't know what. As a writer, as a journalist, do you agree or disagree with me on that?
Oh, no, the wording is absolutely part of it. And they are hyperbolic, like to the extreme.
And do you think that takes away from the strength of the argument?
Of course it does. When you're using hyperbole that everyone knows is a real exaggeration, it does absolutely take away. You were saying that when we were reviewing the other one. It's like, okay, you could have said this in a way that sounded a lot more realistic, but instead you used, undeniable, palpable. These words. These words that are like, okay, well, calm down, calm your tits, like
exactly. Silly. And that's where we are with this, and it's even more egregious. And I mean, it's just, I don't even. We'll let people decide how they want to couch it, but I mean, just some of the phrasing they use, some of the terms they use, is damn near attempts to bully. I mean, it's just like utter disdain for anything that the opponent or the victims or their families
or
could
the
even
jury
possibly think.
Look at the way they talk about the jury, and there's a part in there where they talk about Dr. Newberger as if he's just this old fart who can't.
It's bad.
It's bad. They have this is why we call them the dick defense. It's why I called them the dick defense early on. They have no defense other than to just be total dicks. That's just what they do. It's who they are.
And Tankrat has already kicked us off by gifting 20 Legal Vices memberships. Tankrat, that is insane.
Wow.
Thank you so much, Dan. All of you folks here, if any of you got one of these 20 gifted memberships, please give Tankrat your super special thanks. That is more than generous. But so when we get into this, I'll read the first few pages.
Can I ask the chat real quick? If anybody is on my locals, would you please go and post this? Because I haven't been able to do that, and I can't do it on my phone. Well, so will somebody please go and post in my locals that I'm on live with Legal Vices and put the link on there? I'd appreciate that.
Yeah.
Thank you.
Get this everywhere. I only got up a We're Live Now thing on Twitter, so you sort of propagate this out there because this was literally like it's midnight here but I figured I cannot wait because there's supposed to be a motion on some of this crap happening just hours from now. So I want to get this
and I still
done.
don't know what time that's going to be. So I'm waiting to hear what time the hearing is going to be. I don't think they've said it yet, but I was told probably this afternoon. But we were waiting on permission to be able to share this. So we finally got that, and now we're good.
And I'm just putting up a quick poll here just to remind people here to like and subscribe. Your choices are limited. Have you hit the like and subscribe button? Yes, and of course. So there you go. Hit the like and subscribe button. So what we're going to do, we're going to go through read just kind of the basic background of it, a few pages of that. And then as we get past the table of contents, which in itself is about 4 pages long, I've highlighted the parts I want to read, which are, I said, mainly just, I can't believe they're saying this kind of thing. There's a few of the standard legal arguments.
I appreciate you so much for doing that because I was overwhelmed by this thing. So thank you for doing this.
It took a while to dig through all 144 pages. And it's not like 20 pages with 120 pages of exhibits. This is all motion. All motion. So let's bring this up and get into it, because this hopefully won't take more than a couple of hours, because I gotta sleep and go to work. But this was this important. All right, let's see how big and we can get here. Oh, 2. There we go. All right, that's about as large as we're gonna get, so you can all read at home. So this 144-page motion is in addition to the 39-page motion with the million pages of exhibits that they submitted the other day. Let me bring this up here. All right, we are ready to go. Are you ready, Megan?
I'm ready.
You're ready. Great. Defendant, Johns Hopkins All Children's Hospital, pursuant to Florida rule, blah, 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 timely moves his court. They're moving these court for these main things: to grant 1 renewed motion for directed verdict. So that's, remember way back in the trial when they said, okay, the plaintiffs, they haven't shown anything that any reasonable person in their right mind could possibly conclude as being in their favor. So therefore the judge should just shut this whole thing down and rule in our favor. They're renewing that motion to basically, okay, the jury did this. It was so messed up. It never should have got to this point. Just say we won. Very, very standard. I mean, it sounds shocking, but it's very, very standard. Everybody does. It's a motion that just gets made.
Yeah, I'm shocked by this, Jeff, and maybe that's because I'm not a lawyer. But the reason I'm shocked by it is because I think, well, then why even have juries if we're gonna just at the end of the trial when we lose, just be like, oh, judge, we're look at us, we're poor, starving little lawyers, and we need your help. Why even have a jury?
They're just doing it for the. I mean, it doesn't mean they're going to come anywhere near getting this one through. I mean, they go, yeah, nice try, but check off. But the second thing, this one, so they go, okay, we just want you to say we win, and then if those motions are denied, 2 motions for a new trial, and this is on everything. Motions for a new trial,
and then if those on every count, they want it on every freaking count. Yeah.
Well, and again, I mean, some are more plausible than others, but that's why every time, even if you know that if it gets annoying and bothersome, they keep saying objection this, objection that, because they're preserving them for appeal. Even though they're wrong and they know they're wrong, they still have to preserve it, and they're just gonna kind of take that one last crack because they don't want to give up their money. This is the defendants who had their ass handed to them, that are desperately trying to hang on to their money.
How much money do you think they spent writing this 144-page motion over Thanksgiving?
A lot.
You know,
a lot.
Can we guess how much money it cost to have their entire team?
Thousands and thousands of dollars at least.
And let us not forget that every day that goes by that they don't pay the judgment they were ordered to, it's a 12% interest, $250,000 a day.
Right. And so here, this is their progression. 1, please just say we won right now. If not, give us new trials. And even if you're not going to give us a new trial, they make what's called motions for remittiture, which is basically just reduce the damages. And amongst all 3 of these, the please reduce the damages arguments probably have the largest chance of success. Because
the 6 people at the bus stop couldn't possibly understand what they were supposed to do here. They screwed up. So please, judge, please, we beg you, with our little hat in our hand. Johns Hopkins only has $1.2 billion available cash. We can't possibly pay what we owe.
Creed M says 144-page motion by a 27-year tenured appeals judge costs like 4 kidneys.
Yeah, pretty much. Pretty much.
Right.
Altenburn is working on this. That guy makes like 10 grand an hour, probably.
So close to Rottenborn, we have to use the voice. So again, those are the things they're doing. Just give us the win. Okay, if not, give us a new trial. If you're not going to do that, at least reduce the damages. And as we said, for what claims, as to each of the claims submitted to the jury on the verdict returned on Thursday, November 9th. So everything. They're doing this for every single claim that was made. The defendant also moves this court to grant the same motions concerning each of the claims for punitive damages for the 3 subclaims for false imprisonment and the 1 subclaim for battery, for which the jury returned the bifurcated verdict later in the day on November 9th, awarding a total of $50 million to Maya Kawalski as punitive damages. So they wanted the main claims and all the subclaims and all the punitive damages claims, everything they want overturned or reduced. And the motion is unavoidably lengthy. Yes, it is. But in the end, this court has little choice. See, this is where the hyperbolic thing starts to begin on page 2. The court has little choice but to direct a verdict on all claims.
Only page 2?
Yeah, and see, that's where the judge.
Jeez.
See, and the judge, this is how a judge would read this if I were a judge anyway. In the end, judge, you don't have any choice. You'd be like, well, hell, I don't. And that's how he's going to start. Like, what do you mean I don't have a choice? I'm the judge. You're not. So they're already calling out the judge in the first full page.
Oh, I'm sure it'll get worse because they are contemptuous.
Yes.
They are contemptuous of him.
But in the end, this court has little choice but to direct a verdict on all claims for which this defendant should have received that relief and to grant a new trial on both liability and damages for any remaining claims. The jury voted yes on every possible method to award compensatory or punitive damages against JHACH, maybe because they deserved it. Under the leadership of juror number 1, yes, juror number 1 is back. Under his leadership, they go again and again and again with under the leadership of juror number 1. He's not the leader. He's the spokesperson. He's one of 6. He's not the general marshaling the troops and persuading them to his point of view. He's one guy, but they continue to say under the leadership of juror 1 because the motion was to set this whole thing aside because they fingered him as the leader in this other motion. Yep. Thanks.
That's what I'm here for.
All right, good. Under the leadership of juror number 1, the jury voted yes, despite the fact that under the law instructed by the court and the evidence presented during the trial, many of the claims were not proven, or at a minimum, the manifest, this is the magic words, the manifest weight of the evidence was contrary to a yes vote on those claims. Basically, even though, yes, there was some evidence that would help them vote yes, but when you look at all of the evidence, they were wrong. There was far more weight showing this. They're not liable than they should be liable. So that yes should just be changed to a no and let's go home, judge. That's what they're arguing. This court allowed plaintiff's counsel to use an improper method of closing argument that was intentionally designed to mislead the jury about both the method to decide damages and the reasonable range in which the jury was free to operate. In the improper closing argument, plaintiff's counsel frequently, I don't know where frequently came in there. In the important, all right, I'm getting excited. Calm down and read the words on the page. In the improper closing arguments, plaintiff's counsel requested aggregate damages of $201,573,728. The jury awarded $211,451,174, approximately 105% of that request! Exclamation mark. There's an exclamation mark at the end of that sentence to show you they're shocked that the jury awarded 105% of the amount. Nope. It's just the jury awarded this much, approximately 105% of that request! Exclamation mark. Happens. Like, oh yeah, you're only asking for this much, but we see it differently. How about we give you more? That happens. That happens.
Yeah,
a bit
I mean, that's the other thing. They're acting like a jury doesn't have that wherewithal, like they're not allowed.
Mm-hmm. Exactly. When Karen Ricci, member for 2 months, morning to you, Karen Ricci, and Tankrat member for 14 months. Is this the same filing from yesterday? No, of course not. This is a new filing. This is 3 times longer, almost 4 times longer than the other one. Almost 4 times longer than the other one. This is a brand new filing where they're asking for brand new stuff. Anyways, glad I can watch this while not at work. Well, me too. We're glad you're here, Tankrat. Thank you so much. All right, jumping back into this. Both the awards for the personal injury claims of Maya Kawalski and for the wrongful death of Beata Kawalski are many times higher than the range currently awarded by other juries, and recognized in case law for such awards. Under the leadership of juror number 1, again, they use that wording, the jury's verdict was obviously tainted by the improper closing arguments of plaintiff's counsel.
There it is again, obviously
Mhm.
tainted. I don't
Mhm.
know how they still haven't proved that at all. They're just making shit up.
Yeah. The taint part, they might be taints. We're not sure. The plaintiff's counsel and the defense counsel, they might be taints. But it's sometimes awarded amounts even higher than plaintiff's counsel requested. That happens often. Well, I don't know how often. It's not uncommon that the jury will actually award more than has been asked for. It is patent that the jury did not award non-economic damages as if these claims had been tried separately, and the same is true for economic damages, of which duplication of awards is rampant in the verdict. You're not supposed to duplicate the awards, the same award for one thing as you did for another, and they're just saying they did that. They couldn't possibly have awarded all of this money without duplicating some of the damage awards. Well, that's to be decided, isn't it? This court, before that closing argument, committed to following the law after the return of the verdict if plaintiff's argument resulted in such a massively tainted verdict. Massively.
I mean, did they though?
Yeah.
I don't remember this part of the pretrial hearings. I don't remember the judge saying, "Don't worry, if the jury gives you too much damages, I'll reduce it. Don't worry." I don't remember that.
And I don't think the judge would go, you know what? I'm just going to disregard the law. I mean, of course, the judge is going to follow the law. But they're arguing that as we'll see through this 144-page thing, they're making several arguments that said the judge allegedly violated rules of law many times throughout this whole thing. So the awards are so arbitrary that they cannot even be used as a reliable measure for remittiture or reduction of the claim amounts. Because these reductions of the claim amounts have to be, you have to go, okay, no, the math is wrong. Here's how you should really do the math. He said, these numbers are just so arbitrary, you can't do the math in any way that makes to reliably reduce the damages. So instead of saying remittiture, I'm going to say reduction because it sounds more human.
Right. And people don't understand the word remittiture, but he's just talking about a lower amount. He wants to pay less.
Exactly. A reduction in this case would simply require the court to serve as a fact-finding jury of one. And that's another buzzword. They're saying, when the judge makes these decisions, when he goes in and somehow readjusts what happens, he can't just completely ignore what the jury's done and do his own thing. He can't make these determinations of fact on his own, because then it becomes, as I say, a fact-finding jury of one. The judge is supposed to use what they gave and kind of make corrections. They're saying, you can't do this. If you make any corrections, this is so messed up. The jury got this so wrong that if you were to go in and actually try to do this, then you would essentially be acting as a jury of one. But in any case, that's our last resort, so please do it. That's what they're kind of asking here. This court must grant new trial as to liability and damages on any claim for which a directed verdict is not granted. They're saying, all right, go ahead and completely just flip-flop the verdict, say we won on everything. If we don't get a win on everything, then we have to have a new trial on the ones that you don't overturn. So after the jury returned its verdict determining liability, compensatory damages, and making findings on the substantive issues following for an award of punitive damages under section blah, 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 Florida statutes, this court proceeded immediately with an abbreviated trial on the amount of punitive damages, in part because this case needed to be completed on November 9th for reasons asserted by the court. So it's the judge's fault. We didn't have time to hear this out. It's the judge's fault. You made this, you made this an abbreviated damage thing. Yeah.
That's going to go over well, especially with the last motion that accused the judge of all kinds of crap. Yeah, he's going to love this.
The plaintiff proposed a verdict form for the first time that included a claim under section 768.773(1)(c) that the punitive damages should be unlimited because the defendant had a specific intent to harm Maya Kawalski. Not only is there no evidence that would establish such a claim, but that claim is very clearly a substantive claim involving the entitlement for damages in excess of those normally allowed under the section of Florida statutes. As a matter of basic due process, this claim under the section of Florida statutes needed to be pleaded in the 8th amended complaint by something more than a conclusory claim the defendant acted willfully, wantonly, maliciously. Again, this is just all boilerplate language they throw in to try to get things taken out, but they flesh it out later. The defendant needed to have the opportunity to present evidence on that claim prior to the initial verdict in this bifurcated trial to move for directed verdict on the claim at the close of plaintiff's case and to argue this matter in its main closing. Instead, this court placed this substantive issue affecting the cap on punitive damages on the jury's verdict for the second phase of the bifurcated proceedings, where only the damage amount should have been tried. Moreover, the court declined to decide the question of law concerning the burden of proof for the specific intent finding. It thereby further emphasized this issue by presenting it twice to the jury under optional burdens of proof. The jury then returned a verdict, again voting yes on everything, quote, under the leadership of juror number 1. They really, really, really want juror number 1 to be the driving force behind all of this, because they're saying he was behaving improperly.
This is becoming defamatory against him. I'm getting sick of this. It's
shockingly ridiculous to keep saying under the leadership of juror number 1.
Well,
the jury
how much more can they do this before he has a case against them? Like, you didn't prove I did anything wrong, and you're besmirching my good name everywhere in every legal document. Like, what the hell? Enough.
Well, the jury awarded $50 million in punitive damages. It awarded $25 million for 2 false imprisonment claims for periods where Maya Kawalski was treated in an intensive care unit, and 2, she was observed for 2 days in a rather ordinary hospital room, and the video recording and evidence shows no mistreatment warranting any punitive damages. The jury awarded another $25 million for a combined false imprisonment and battery, where she was placed on a bed, either in her own hospital room or some other hospital room, for a matter of minutes on January 6, 2017, which is the day she went to the courthouse. She was just placed on the bed, just for a matter of minutes in an ordinary hospital room, when all of the photographs were taken of her nearly, if not totally naked body.
Wait till you get to that. He's
Yeah.
actually going to make the argument that they did nothing wrong in the photographs. They're just pissing off the world. If they think they're going to get another trial, what jury on earth now, because everybody now knows, is going to come up with anything else? They're going to get hit with a bigger verdict.
Well, yes, that is if there is a retrial, that is a good possibility. And just to show you a little bit how a little bit of the sleaze, a little bit of the scumminess gets in here, as far as I can see it. Again, they get this. She was placed on a little bed, either in her own hospital room or some other hospital room, just for a matter of moments. The day she went to courthouse. Oh, by the way, this is the day her mother wrote her suicide note, unaware of this incident.
Keep her name out of your mouth. Just
Maya
stop
Kawalski.
it.
Now, some of you that may have some ideas of what you think happened when those photographs were taken may be mistaken, because Maya Kawalski was held on a hospital bed to document the condition of her skin photographically prior to leaving the hospital. She has her shorts and bra on for these photographs, which were not shared or publicized at all by the defendant. It should be noted that the defendant maintained that she was actually photographed again on her return, but in light of Maya Kowalski's insistence that it occurred once, this verdict is only for a single event. 2 things there. 1, we didn't show these photographs of her like this. That was the plaintiff's. It's the plaintiff's fault. Any of you ever saw or heard of these pictures, these reportedly improper pictures? That we didn't do that. We didn't show those pictures. Oh, and by the way, we said it was photographed twice, but Maya, she said it only happened once. So, all right, once. This is ridiculous.
And not to mention that they are leaving out the part where they had to hold her down while she cried. And the point is not about whether or not they showed the pictures. It was that they took them at all, that they had and they didn't put them in the medical record because there was no medical purpose. This is these people do not get it. Greg Anderson is 1,000% right. They will never get it. They do not care about this child.
And just in case we know, little victim blaming-ish. Maya Kawalski saw both her uncle and her psychologist, Dr. Duncan, on that same day. She seemed essentially normal to her uncle on that day, and she made no complaint to Dr. Duncan.
Oh my God.
The jury determined this conduct was more than an intentional tort. It decided that it was, quote, intentional misconduct under the definition of Section 768.72 Florida statutes, and awarded an amount of punitive damages that would be excessive even in an Engel wrongful death case where the plaintiff suffered for years with breathing disorders allegedly brought on by an addiction to cigarettes caused by the fraudulent conduct of a large for-profit international corporation. So they're just saying you gave way more to her than you would to someone who had been dying slowly of smoking over the years.
Yeah, well, they drove her mother to suicide, so sorry, but she gets more.
Now, why this isn't even longer and more convoluted is because this motion is filed within the mandatory 15-day window that is provided for all cases without regard to their complexity or trial length. Although a full transcript was requested shortly after the return of the verdicts, and some transcripts of portions of the trial are available now, the motion for this exceedingly complex and lengthy trial is not as comprehensive as it would be with a full transcript and with sufficient time to address a case that is easily 9 times more complex than the normal case in which such a motion is filed. Where does this 9 times number come from? That's just weird. I don't get this. Easily 9 times more complex. What, 8 times is not too complex, and 10 would just be ridiculously complex?
This is
just
their
a weird
MO.
turn of phrase.
They're hyperbolic. This is just them doing what they do. 9 times more complex. They could have just said twice as complex and gotten the same point across.
Or even more complex. Easily 9 times more complex. It's a weird turn of phrase that just kind of makes you go, huh?
And again, they're setting up the argument that no regular person, except lawyers are so special that only lawyers can understand the complexities of Chapter 39. Fuck off, Mr. Hunter and Mr. Shapiro. We're not morons at a bus stop. We can read, we can comprehend, we know what immunity is. I've explained it on my channel multiple times. People get it. And to keep saying that this is too complex for the plebes to understand, it makes me so angry.
Well, you're going to be angry because that's the running theme through this. That's the running theme.
Just pisses me off.
Rule 1.530B specifically provides for an amendment to the motion to state new grounds. The defendant sought to identify each ground for this motion, but it will seek to amend its motion for any additional ground and to provide greater factual information and legal argument as soon as that is feasible. Well, so more to come from the defense is basically what that's saying. Now the lengthy table of contents kind of tell you where this is going. They set forth the applicable standards for these motions. And you can see how they're going through a renewed motion for directed verdict. They're going to they're trying to renew that to say, just give us the directed verdict. Just say, okay, the jury said this, but now I'm going to go back and I'm going to say, okay, the defense wins everything. That's what they want. And then if that doesn't work, they want a motion for a new trial based on manifest weight of the evidence. In other words, even though they said yes, and even though there may have been a little evidence to show yes, there was more evidence saying no. So you should go with the more evidence showing no. Motion for a new trial based on errors occurring during the trial. Motion for a new trial based on excessive awards. And then failing the motion for a new trial on excessive awards, then judge, just go back and here's the numbers that we think you should reduce the award to. And they want more motions for directed verdicts on the punitive damages, the same thing. Either it goes against the weight of the evidence, there were errors in trial, it was an excessive award, and if we don't get a new trial for an excessive award, then just not make up the numbers. Just here's the numbers we think you should find reasonable. And then they go through the issues that affect the claims, the court's errors in applying 39 immunity, the court erring in allowing the plaintiff's attorney to make these massive requests for damages, the errors in the decision to grant the defense motion for directed verdict on negligent training claims only at the very end of trial, which allowed the jury to become confused and misled by irrelevant evidence that impacted many of the claims in the case. And then to grant additional, he erred in granting additional time to the plaintiffs, which severely prejudiced the defendants. and to allow Dr. Newberger's deposition testimony over objection. They really didn't like Dr. Newberger.
Oh, they hate him. And the reason is because he is the founding father of pediatrics in general anyway. And so his background is so rock solid that you cannot discount what he has to say. And he hates child abuse pediatricians. So of course they don't want to hear him. You know, he has testified in other cases about this and successfully won on the side of parents. So they fear him.
And I mean, they have special loathing for him in the wording of this motion.
Oh yeah, they call him like an old fart. Basically, they're like, despite his advanced age, like it's incredible what they say about him.
So here's and then they have the motions for intentional torts, the false imprisonment, the all of the various false imprisonment claims that they brought, and every one of them goes down the same thing: motion for a directed verdict, motion for a new trial on excessive compensatory damages, motion to reduce the award, and they just kind of go through these for each one of the claims. And it's not shocking they're doing this in the form they're doing, because these are standard issues you would raise in your appeals, in your desperate attempts to not give money.
Yes, but don't you think they would have been way better served to just stick to the reduction arguments? Because I think they actually could get some of them. Like if they showed, okay, historically, this is way too high, it should be around here. I think the judge would be far more willing to maybe make a couple of adjustments than he will be to direct a verdict and overturn a jury's will.
Yes.
They shouldn't have done any of that. They should have stuck to, okay, all right, we lost, but this is too high.
Yeah, they're it's a CYA thing. It's a desperate Hail Mary attempt they can get they're making to try to get whatever they can to make so they don't have to give money. It is standard. I mean, it's kind of BS-y, and a lot of it, the judges go, okay, check off that you did this box. Thanks for your arguments, but I don't think they have any weight, which is where most of these, if not all of them, are going to go. It's just one of those. We keep getting asked, what is remitter? Remitter is just saying reduction of the damage amounts. You awarded this much. It's just, oldie timey speak for reducing the amount of damages awarded, where the judge would say, okay, the jury awarded $5 million for this. That was improper for this reason. The proper amount to be awarded is $5. So it's just reducing the amount awarded. They do that for the false imprisonment claim for October 18th to 20th. They do it again for the January 6th. It's all the same motions for each one of the charges. The battery charges, the battery for hugs and other touches arguments, the intentional infliction of emotional distress arguments, the medical negligence arguments, and then there's issues claiming the billing fraud. We're not even going to look at the billing fraud thing because, that's the least exciting of all of these. And issues affecting the claims presented by the estate of Maya Kawalski, which are the intentional infliction of emotional distress, seeking survival damages, the intentional emotional distress causing death by self-deletion. So their table of contents is almost 5 pages long. So now what I want to do
I couldn't believe that. I sent that to my sister. I sent screenshots of the table of contents to my sister, and I was like, seriously, look at this. I mean, she just started cackling. It's ridiculous how long this is.
Yeah, I mean, it is a very complicated, lengthy trial, but they literally didn't accept a single one of the claims. They went for every one of them. Even the what was it? A few $1,000. There was like $1,000 award to Mr. Kowalski. They couldn't even let that one.
They're
go.
Never going to admit that they're wrong. It's sick. It's sick. They're not going to admit they have any liability whatsoever. Wait till you get to the argument about what they about the how this judge should get a list from the plaintiff about the actual things that Johns Hopkins did. And it's like, okay, where do you want me to start? Let me make a list for you, Shapiro. I've got a list.
Megan, you seem animated about this.
Look, I feel like I told love Greg Anderson. I feel like I've been through a war with you. And I do. I feel like we have been through a war. I mean, these poor people have been slandered and maligned for the last freaking time. I'm sick of it. I am sick of calling a child who is suffering this awful disease a liar. You know, one of the best things that happened to me during this trial was meeting Mo in the Deep End, who has an amazing channel that is criminally undersubscribed. Go and subscribe to Mo in the Deep End, who actually suffers with CRPS. And hearing her describe what it's like, and she looks totally normal. You would never know that this woman is suffering a massive pain disorder. And to call these people liars, it is an outrage against humanity. I am sick of it. And I can't believe they're keeping this up after the jury has made their verdict. Moms are pissed because I can't imagine having a child in pain like that and having them be disbelieved and then also tortured, slapped and hugged and tickled and by nurses who think they're making it up when you know it causes them agony. Let me count the ways, Mr. Hunter, that you have done these things. And your hospital is liable no matter what you say. Anyway, sorry. I'll shut up now.
No, that's what we're here for. We've got a few super chats to get through here before we move on to the main section of the brief, which lasts 1 billion pages. Juror number 1 is here. Greetings, y'all listening in. Thank you so much for being here. Michael DiRado, sorry. Megan, you could hold your liquor better if you were only a man. Megan is pretty good on her own, let me tell you. Ike Evnar is late to the party, but I'm 9 times more confused about this motion. Easily 9 times more confused. Well, if you were smarter, then which is what they're going to say. Again, that's the recurring theme that the jury was just too dumb to get it. And Tank Rat with the AED 100. Are the two sides going to settle like Depp v. Heard after the trial, or is this Hail Mary going to be it before appeals court? I don't think they're going to settle. They're big pharma. They're big medicine. They're big hospital.
Very clear they are not going to settle. They're going to fight to the bitter end. They're going to make it as painful for the Kowalskis as possible because that's their MO, making it as painful for these people as possible. And that means that they're going to do the same thing to the Kushners and anybody else who brings a lawsuit. This is a warning, by the way, Jeff. What they are doing is warning all the others because you heard 400 to 500 people have been investigated by Sally Smith and Kathy Beatty. So this is a warning shot.
Well, it should also be a bit of a self-warning because at some point they need to be careful. Otherwise, at some point, the tide of public opinion is going to turn way against them. The people that had no inkling of this trial are going to hear about it. They're going to hear what's going on, and it could be devastating to their reputation.
Do you know how many people I already know who are saying, I never watched this trial, but I'm going back and watching it now? It's already happening. And public opinion is already turning. The anger that is building out there is, shall we say, palpable.
Creed M says, wow, Megan, this isn't a motion for a new trial. No need to be hyperbolic. Oh, this is a motion. This is several motions for a new trial. And the hyperbole is just getting underway, probably from both of our sides, from our side and the defense side. Oh my Lord, this is here we go. Let's dive into it. Here are the applicable standards for these motions. The defendant first seeks a directed verdict on most claims, all that I could see. Maybe there's some they weren't. Should the court deny a directed verdict as to any claim, the defendant alternatively seeks a new trial on those claims for which a directed verdict has been denied. If the court denies a directed verdict and a new trial on any claim, the defendant next seeks reduction of the damages associated with those claims for which a directed verdict and new trial have been denied. The defendant's not waiving its right to appeal by raising alternative motions in the event the earlier motions are denied. So they're just saying, okay, if not this, then this, if not this, then this, if not that, then the other, but we're still arguing everything. We're not giving up anything by arguing these alternative solutions. The renewed motion for the verdict here. It is more, and again, I'm highlighting the things that annoy me about this. okay, I'm highlighting some of the factual things, some of the background, some of the standards, as well as some of the ridiculous things that don't reflect well on the defense or their lawyers, I feel, in my opinion. A renewed motion or a reserved motion is subject to the same standard. Sometimes, however, it is more important to the end of a case that an essential element of a claim was not supported by any relevant evidence, or that the evidence at issue was not in actual dispute.
Wait, so it says it was more apparent. It wasn't important. It was apparent.
Oh, did I say important?
You said important, so okay.
It's okay, yeah. It is more apparent at the end of a case that an essential element of a claim was not supported by relevance. That's what you're talking about when you're talking about a directed verdict. You get to the end of the plaintiff's case and you go, okay, there is no relevant evidence whatsoever to support the essential elements of that claim. So therefore, we don't have to put on a defense because they didn't even put forth the legal grounds for their claim. So rule in our favor. So with the initial motion, the trial court has the luxury of anticipating that the jury will likely vote in favor of the party moving for a directed verdict. Once the jury reaches a verdict, influenced by prejudice, passion, or simple confusion, it is the duty of the court to make the objective decision based on law and actual evidence.
Can I ask you something, Jeff?
Yes. Yes.
If a jury came to a conclusion and based on their confusion, and they got confused, isn't that the defense's, the losing party's fault for not explaining it to them properly?
In a great many cases, yes.
So, like, that's your own damn fault. If the jury was confused, you didn't do your job. And if you didn't do your job, I'm the judge that says, I'm sorry, you didn't make a good enough argument. Goodbye, double guns denied.
Double guns.
Double guns. Double guns.
And here's the legal standards for motion for a new trial based on manifest weight of the evidence. A motion for a new trial based on a verdict that is contrary to the manifest weight, the majority of the weight, the greatest amount of weight of evidence. Majority is probably the wrong word to use. So a motion for a new trial based on a verdict that is contrary to the manifest weight of the evidence may be granted even when a motion for a directed verdict is unavailable. Quote, this is from another case here. The trial judge should always grant a motion for a new trial when the jury has been deceived as to the force and credibility of the evidence or has been influenced by considerations outside the record.
Okay, well, nothing has been influenced outside of the record, so that's out because nothing came in that was outside of the record. So,
well, there are aspects of this case. There are aspects of this case, Megan, that made it difficult for the jury to weigh the evidence or follow the law. The medical and scientific evidence was complex and overshadowed by the emotional impact of a good family devastated by a dependency proceeding that was beyond the defendant's control.
Well, that's weird because they didn't suggest they were a good family. They told us they were a bunch of money-grubbing liars, is what they said. They didn't start with they're a good family and they're good people. They said that she's a liar. And her mother's a liar, and her father's a money grubber. So, yeah.
Yeah. Well, moreover, the tort of intentional infliction of emotional distress, even without the additional unique factor of self-deletion in this case, is a difficult intentional. It's a difficult intentional tort for a jury to understand.
We're back to the jury is stupid. 6 people at a bus stop argument.
In this case, the jury needed to sort out any actions of the defendant's employees that were more than negligence and more than a mere traditional intentional tort. They needed to identify conduct that actually arose to the level of extreme and outrageous conduct committed with the intent to, or with reckless disregard of the high probability of causing severe emotional distress.
Again, I can make a list. This is where it starts, where he's like, we didn't do it. We didn't do nothing.
Yeah, it was the dependency court that started this ball in motion, and anything we did, it wasn't intentional.
Forget that we called DCF once and they said you don't have a case and hung up on us. And then we fabricated evidence so that they would come back and take this kid from her parents. We know you did this. You did it, not the dependency court. You fabricated evidence so that they would take this child from her parents. So, yeah, no, sorry. We saw the evidence, and that came into trial that there were 2 phone calls, not just 1, 2. That was extreme and outrageous. Damn right, Bucks.
Mm-hmm. Well, their argument continues here, about the poor jury here. They needed to identify conduct that actually rose to the level of extreme and outrageous conduct committed with the intent to or reckless disregard for the high probability of causing severe emotional stress. To perform that task, when presented with an emotional case and with a family sitting for weeks at the trial table, and in a high-profile case presented to a national audience, would be nearly impossible for most juries, even with a different foreperson. Even without the driving force of juror number one, as they're alleging, even with just a normal person as a foreman, it would be so impossible for them just to sit there for weeks and try to figure out all of this while staring at a family. This is all just wrong, Your Honor. We need a new trial, or better yet, just say we win.
It's insulting. This is insulting to those people who gave up so much of their lives and listened to all the evidence and sat there. And, I am so sick of this other class of people who have higher degrees, and they think that they're somehow better and more equipped to understand things than the rest of us. Fuck off. That is not the way this country was built. It is not the way this country was formed. This country was formed for the people, by the people, even if there are a bunch of rubes at a bus stop. It's the people who make the decisions here, assholes, not the lawyers. Sorry, we put lawyers in office, but you know what they're there for? They're there to do our bidding. I'm your boss, bitch. Me, the one sitting at the bus stop that you look down on. I'm still your boss. I'm still your supervisor. God dang it, Jeff.
Yep.
I'm sorry.
The court.
I have to calm down. I need to take some deep breaths and do some yoga or something. Okay.
Some squats.
I'm getting really heated. I'm getting upset because
I know.
This is a problem that is pervasive throughout our entire country right now. Our institutions think that we are morons. They think that they can tell us what to do, that they can direct our economy, they can direct our lives, and they think that they are in charge, and they are not. Okay, I'm done now, Jeff. Go ahead.
Megan Fox, the voice of reason. The court is given a higher gatekeeping function for this unusual tort, and that function continues through the decision to determine that a verdict was against the manifest weight of the evidence. Now, finally, this standard and the job of the trial court is even more important in this case, in which the theory is that the employees of the defendant committed conduct that was so extreme and so outrageous that it was a legal cause of a person's suicide. A suicide that occurred not because those employees directly interfaced with Maya Kawalski after October 13th, 2016. Instead, a suicide that occurred because... I've lost my place. Instead, a suicide that occurred because extreme and outrageous conduct of employees inside the hospital was either described to Maya Kawalski by her husband or were experienced by her through some remote form of communication.
Wait. Yeah. Hold on. It could be argued that they interacted with her through the absence of interacting with her. They banned her from the hospital. Mm-hmm. They banned her from knowing about her child. They banned her from her child. The absence of asking for her parental permission, getting her consent, the absence of all of those things could be considered the interaction they had with her. And that's the extreme and outrageous conduct because they did it against court orders, not allowing her to have her court-ordered visitation. That's outrageous and extreme. Let me make a list, Shapiro. We're making a list. You guys start writing it down. There's a list.
There's more room to make lists. We're just getting started. A suicide that purportedly is the legal responsibility of the defendant and not the intervening independent act of Maya Kawalski, because somehow the defendant's employees intended their action to cause this extraordinary level of stress in a woman many miles away, a woman that some of the employees had never even met. Well, yeah, they'll talk more about that later.
Do you need to meet her to be causing her distress? I don't think so. If you are involved in keeping a mother away from her daughter unlawfully, you are the cause of her stress, period. If you're involved, You're part of it. And if you're just following orders, that didn't work for Hitler's boys.
So
So
no,
give
don't
me
say that
shit.
word. Oh my God, we're just done.
I'm not allowed to. We're not allowed to say the H word.
Yeah.
Really?
Yeah.
I
Oh
didn't
yeah.
know that.
Yeah. Oh yeah.
I'm sorry.
Yeah.
The Nuremberg defense.
And either of the N words, the one associated with the H guy or just the other one, and the S word that we've already used. Oh yeah, YouTube doesn't like that at all.
I didn't know that, Jeff. I'm so sorry.
No,
well,
it
we're already
doesn't
yellow. We're
matter.
already
Well,
yellow.
we went green again. I've been watching it, but we'll see. It doesn't
Sorry,
matter.
Jeff.
It doesn't matter. Continuing with the basis for the legal standards here. Motion for new trial based on errors occurring during the trial. A motion for a new trial based on legal errors occurring during the trial is analyzed separately from a motion based on the manifest weight of the evidence. Saying you got to consider the legal errors separately from the jury was confused by the evidence. A new trial is required where the trial judge becomes aware of a specific prejudicial legal error, or when he or she finds that the jury's verdict is contrary to the manifest weight of the evidence. This means that when considering a motion for new trial based on a prejudicial error, the trial judge, who must decide whether to grant a new trial on the proffered ground that some reversible error of law occurred at some point during the trial, need only ask himself if there was an error, and if so, whether the error was substantially prejudicial. So that's really basically the standard. The judge goes, okay, did I make an error on this, and did it prejudice the outcome of the case? In that instance, the judge is required to sit, in essence, as an appellate judge. If he concludes that reversible error has been committed, the judge is obliged to grant a new trial on the same basis that an appellate court would do so.
Okay, so that's where I was kind of confused. So I did not know that a trial judge could kind of take the place of an appellate. I'm reading this going, why don't they just file their appeal? So what is the deal with this? They want this judge to act like an appellate judge. Why? Yeah.
Well, this is sort of like the last step before the appeals. They go, okay, before we go to the appeals, we want you to decide. Here's all of the issues we think you did wrong from a legal standpoint. You misapplied the law in this and this case. Look at that. If you in retrospect feel that you did make an error of law, was that error prejudicial to the outcome? If it was, let's go back and have a new trial. If the judge says, no, I'm pretty happy with all of my decisions, no new trial, then they go and file the appeal. And they say, hey, this guy made these errors of law and he didn't correct it. So it's kind of like the last final review by the trial.
Is it like a money saving effort?
Well, yeah, and to not bother the appellate courts with clear errors of law and things like that, not to keep the docket as free as possible.
It's interesting to me. It's just interesting. Poor Judge Carroll had to read this over his Thanksgiving break, by the way.
Yeah. So, I mean, it's exactly what they're doing in what they did before he stepped away with the motion for the judge to recuse himself in the Murdoch trial. He basically said, okay, here's why you shouldn't have anything to do with this case. What do you think? And then he goes, no, I think I should. And then they go to the appellate. Okay, that was a bad mistake. That was a mistake.
Holy
that's not
crap,
what they did.
Guys.
That's not what they did in that case. Forget it. Just delete the last 30 seconds of what I said.
Holy
Forget
crap,
it.
Jeff, guess what just arrived at my house?
What just arrived at your house?
Hold on, I got to show you guys. How do I turn my camera around on here?
I don't know.
Probably set it. All right, well, I'll just turn the camera around myself. Oh, here we go. Gregory Anderson just sent me his book, Iron 44.
Oh, cool.
And look at how big it is. Oh, my Lord. I wonder if it has a lot of pictures. So he wrote this book about his the true story of the deadliest firefighting crash in U.S. history. He won $70 million for his client in this case. It was a landmark case, and this was against GE. So he said he was sending me this book, and oh my God,
big book!
Look at the size of it. That's a
large. That's a tome. I believe we call that a tome.
It is 778 pages. It is actually longer than my ridiculous book that's really, really thick. Mine is 600 and some pages. He got me beat.
Wow.
So on my locals, we're actually going to be reading some of this. I don't know if we'll get through all of it, but we're going to do it. So this is so cool. Thank you, Greg. He didn't sign it? Oh, no, he did sign it. Okay. I was just going to say.
He's like, Secretary, can you do this for me? Just stick it in an envelope and send it off to her. Maybe she'll leave me alone.
He did sign it. He said to Megan, thank you for your courage of my latest verdict. for your coverage of my latest verdict. Here's a controversial older one, Greg.
Mhm.
Cool. All right. Anyway.
That's cool. All right. So back to the errors of law here. The moving party for a new trial. So that would be the defense who's moving for a new trial must show that there was error. And if so, if they say, okay, here is the error, we've shown you there is legal error, then the burden shifts to the plaintiffs to show that the error did not contribute to the verdict. Standard. Motion for new trial based on excessive awards of damages. A trial court may order a new trial on the ground that the verdict is excessive. The motion is distinct from the new trial that can be granted after a reduction is rejected because reduction is not proper where both liability and damages have to be retried. That's just kind of things. This motion is based on errors during the trial affecting both liability and damages, and not merely the jury's own mistake in awarding an excess amount. These are often errors that cause the amount in the verdict to be so unreliable that the verdict cannot even be used by a judge to remit a lesser amount that is legally appropriate without merely becoming a jury of one person. A new trial may be ordered based on an excessive verdict when, quote, the record affirmatively shows the impropriety of the verdict or there is an independent determination by the trial judge that the jury was influenced by considerations outside the record. The legal question is whether the verdict is so inordinately large as obviously to exceed the maximum limit of a reasonable range in which a jury may properly operate. See, this is kind of a new standard. The old standard used to be shock the conscience. If the verdict was so large it would shock the judge's conscience or shock the public's conscience, then it could be reduced.
But these days we've seen billion-dollar awards.
Mm-hmm.
So how could that be shocking? How could a $261 million award be shocking? It's not even that high. It could have been much higher. I was hoping for $1 billion.
That would be overturned, I bet. Very quickly.
I'm sure it would.
So I mean, the shock the conscience isn't the standard. It's kind of the older standard. Back when I started doing this thing, they'll talk about the new standard later here. Well, in this case, for many of the claims, the awards in the verdict are so excessive and so beyond the proper range due to the improper arguments of plaintiff's counsel that this court allowed him to make at his own risk, that they really provide no benchmark from which this court can perform a reduction as a question of law. Moreover, as a result of additional errors, a new trial is warranted on all issues for the claims in this case. And the motion for remitted or reduction of compensatory award of damages. The standard for this, the defendant in this motion will move for reduction only as a last resort. The defendant does not actually believe that any of the monetary awards in this verdict are sufficiently accurate and unaffected by passion and prejudice such that they could be used by the court to make a legal decision. So they're saying
passion and prejudice sounds like it should be a novel.
Yeah. Nice. That was good.
Maybe I should write one.
Yes,
maybe I should write the story of Maya Kawalski and JHACH and call it Passion and Prejudice. And the prejudice, by the way, spoiler alert, it's all on JHACH's side.
So what they're saying here is that this motion for remitted, or that essentially again is them asking the judge to just go in and say, okay, this was what you awarded, but I'm going to award this much. But they're saying that's improper because the judge just can't do that. There's no basis for him to do this because the jury was so improper in their award that the judge just can't go in and correct it that way. So what they're asking for is a new trial on the damages portion, as well as on the whether or not to give them damages in the first place portion. But this is only a last resort. If the court doesn't grant them a new trial, they want the judge to consider just assigning some numbers instead of the actual verdict amounts. That's okay. The statute lists the following factors to consider. Well, this is when reducing the claims. Whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact, i.e. the jury. Whether it appears that the trier of fact, the jury, ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damage recoverable, whether the trier of fact took improper elements of damages into account and arrived at the amount of damages by speculation and conjecture, whether the amount awarded bears a reasonable relation to the amount of damages proved and the jury suffered, and the injury suffered, not the jury suffered, and the injury suffered, and whether the amount awarded
did suffer.
Did suffer.
They did suffer.
Whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. So the judge couldn't increase could the judge increase the judgment? No, the judge couldn't increase. They can only
But I feel
reduce
reasonable
if there's a legitimate amount.
I think that phrase "reasonable persons" is important because I think that this was a reasonable verdict by reasonable people. Look at the punitive damages; they could have gone much higher, and they didn't. It has a much better chance of surviving because they didn't. That says reasonable to me.
Yeah, well, and who is the reasonable person? It's the everyman. It's not a specialist in a field. It's not a particular person with particular qualifications. It's everyman. It's you. It's me.
It's the six people at the bus stop.
At the bus stop, exactly. And what about the renewed motion for directed verdict on claims for punitive damages? Well, the standard for that is intentional misconduct. You need intentional misconduct. For that statute means the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result. And despite that knowledge, we'll talk about the text messages here in a minute. Let's get through the basis for findings. Then we'll get into the specifics.
I'm sorry. I'm muting myself.
So let's start again here. The intentional misconduct for that statute means the defendant had actual knowledge of the wrongfulness, the high probability that injury or damage would result, and knowing that it was wrong and knowing that the damage or injury would likely result, they intentionally pursued a course of conduct that actually resulted in the injury or damage. Or gross negligence, that means the defendant's conduct was so reckless, so wanting in care that it constituted a conscious disregard or indifference to the life, safety, or we're going to do, we don't care what the reason, we're just going to go balls to the wall and do this we don't care about, what happens basically. We know this is a reckless, dangerous course to go on, but we're just going to do it anyway. That's kind of what that is. In this case, the torts are not matters of negligence. They are intentional torts. There's negligent torts where, oops, I made a mistake and did something, or intentional torts, which are I intended to do this act. And this is what happens. So they are intentional torts of false imprisonment and battery. The awards in this case should not have been allowed to be based on gross negligence as compared to intentional misconduct. But this court ruled otherwise. So they're saying this is an error of law. The court mistakenly ruled on the foundation for the awards. But this court ruled otherwise. Even under the gross negligence standard, the defendant submits that it is entitled to relief on its renewed motions for a directed verdict. It is also entitled to a directed verdict because there was no evidence that a director or officer of Johns Hopkins committed any of the acts specified in section of the Florida statutes. The purported manager involved in one of the claims was merely employed as a risk manager in a risk management department. So they're saying it wasn't anybody of super importance in the hospital that did these, that was responsible for this. So it couldn't have been the hospital doing it. And then there's the motion for a new trial based on punitive damages, contrary to the manifest weight of the evidence, which again is just saying, we know they came to this conclusion, but the manifest weight of the evidence says otherwise. And then there's the motion for a new trial based on errors occurring during the trial relating to the punitive damages. Okay, are we ready to look at the actual facts of the case? We've got through this. This was them just sort of laying the foundations. Let's see, how are we doing here?
We're only at an hour. That's not bad, Jeff.
Yeah, good. I know. We're like 5% of the way through this thing.
I know, but we're not going to read every page. So,
all right, we're doing good. We've got 892 people here and 500 likes. So thank you very much for that. Again, just real quick, Megan Fox, go check out her channel. It's not the thumbs, it's the other one. Megan Fox. You got to hate it when we say that, don't you?
No, I don't. I think it's funny.
It's Megan
okay.
Fox Writer.
I'm used to it. In fact, it happened at the I ended up in the hospital last night. I had to take my husband, and he had a bad reaction to some medication. And so we're sitting in the hospital, and the nurse comes in and she goes, "What's your name? And who's your wife?" And she looks at the file and she goes, "Oh my God, you're married to Megan Fox?" And I'm sitting there. I'm like, "Yeah, that's me. Would you like my autograph?" It was funny.
Go check her out, Megan Fox Writer, here on YouTube and locals. meganfox.locals.com, right?
That is correct.
That is
yes.
good.
Please go and check me out there. And that's where you're going to get all my notifications too, by the way, for when there are lives. And also on Locals, we watch movies together, documentaries together. We cook together. I've got Mr. Fox may be doing a cookie stream for you guys soon for Christmas cookies, which is going to be fun.
And I'm sure that when we get done with this motion tonight, you're going to have a few more. There's enough that Megan could continue commenting on this motion for weeks and weeks and weeks.
Oh, absolutely. I still haven't even read it all completely. So once I do, I'm going to hopefully write some articles about it. Oh, by the way, speaking of articles, I have a new one up with Greg Anderson's comments towards the media and what they have done regarding this case, which you will not see anywhere else, exclusive to pjmedia.com. So go over there, go to authors, click on my name, and you'll find the newest article with Greg's new comments about it. But he's not given up. And nobody's given up on this family. So this is going to be a fight to the death.
Again, and Megan is covering this way more than anybody else. I've just kind of been doing these motion hearings over the weekend while she's off doing Thanksgiving-y things and taking care of other things. And I don't want to do these without her because this is kind of her gig. This is what she's been doing from day one minus the last 20 years. So she's up on these way more than me.
You're so sweet. Yeah. I told Jeff today when he was like, "I'm doing it." I'm like, "Okay, I can come, but I have to do chores, so I need to be mobile."
Yeah, and I said, I'm not doing this without you because this is your gig. So everybody go to Megan Fox Writer, meganfox.locals.com, subscribe to her, watch what she's done, watch what she is going to continue to do on this. I'll do things as opportunities arise. But while you're here, hit that like button if you don't mind. I would deeply, deeply appreciate it. And if you haven't subscribed, I'd appreciate it if you just give me a chance to be part of your regular YouTube rotation. With that out of the way, let's do these super chats that are outstanding, and then we'll jump right back into this. Don't want to have them or it have it stand out too long. Marvin White says, "Wait, what day of the week is it?" It is Sunday for most people. We're off into Monday for a few of us, but it is Sunday. Welcome, Marv White. Thank you so much for the super chat. Okay, folks, let's get into the meat and bones of this. Let's get into some of the unsavory parts of this. The motion for a new trial based on excessive awards of punitive damages. Sorry, this is still the last one of these.
Jeff, if I disappear, I'll be right back because I have to change cords here. Okay.
Cool. All right. So asking for the excessive awards for punitive damage, the new trial for that, consistent with the standard of a new trial based on excessive compensatory awards, a trial court may order a new trial on excessive punitive damages. So they're asking for the same thing. They want a new trial for the excessive compensatory awards and a new trial for the excessive punitive awards. And then they've got the, reduction of punitive damages, basically the same thing. U.S. Supreme Court requires courts to consider 3 guideposts in determining whether the award of punitive damages is unconstitutionally excessive. Now, the punitive damages, that's kind of where they get to go crazy with the amounts. That's where the jurors get to go, all right, we've compensated them for the actual damages they've suffered. Now we're going to punish them with other amounts. The punitive is punishment money, punishment for them doing what they did that got them found liable. So in determining whether the punishment money, the punitive damages, is unconstitutionally excessive, the Supreme Court looks at the degree of reprehensibility of the defendant's misconduct. How reprehensible was the defendant's misconduct? Seems pretty high to me in this case. The disparity between the actual or potential harm suffered by the plaintiff and the punitive damages award, and the difference between the punitive damages awarded by the jury in the civil penalties and the civil penalties authorized or imposed in comparable cases. So they will look at other comparable cases and go, okay, this guy awarded $1, and in a similar case, this jury awarded $50 bajillion. Okay, $50 bajillion is a bit excessive. Those are some of the standards they look at. So in this case, the $50 million in punitive damages bears no relationship to the injuries or the damages actually proved to be related to false imprisonment or the battery that violates due process. This motion is only requested after the denial of motions for directed verdict or a new trial. The defendant intends to appeal the denial of those orders as adverse rulings, issues affecting all claims. All right, the court erred. This is a court error in the application of Chapter 39 immunity. This is what they're arguing. They're arguing that the judge erred in applying immunity.
Okay, but let's also keep in mind that it was the defense itself that wanted and argued for Chapter 39 immunity to keep all Chapter 39 issues out of this trial. So just keep that in mind as we read this.
Prior to trial, this court granted a summary judgment determining that the defendant had statutory immunity under Florida statutes for reporting the claim to DCF, for the investigation of that claim, and DCF's decision to pursue a dependency proceeding against Beata and Jack Kawalski. In exchange for obeying the statute and for cooperating in good faith with the dependency court and DCF, the defendant was entitled to immunity for any act authorized or required by Chapter 39.
And I do have to say, Jeff, I think the judge made a mistake there. I think personally that the first phone call should have been immune, but the second call should not have been. And I think that was his major mistake. The mistake was he should have seen that they went out of their way to make up some more evidence when DCF said, no, we don't want this case. There's plenty of evidence that her physicians are directing her medical care, because DCF called the physicians and found out that the ketamine dosages were being administered by board certified physicians, and they said it's fine, leave her alone. So the second call, the first one, fine, they had every right to call. They were curious, they were suspicious, fine, but DCF told them this is not abuse, so move on. And they then cooked up stories on their own, and that should not have been. So I believe the judge erred in doing that.
Well, he still won, though. Even if we assume that he made an error in that regard, the plaintiff still won. Yes. But what the defense is arguing is that the immunity should have been extended. They should have been given broader immunity to complying in good faith with multiple orders entered by the dependency court regarding visitation and communication. But the court interpreted the protection given to the hospital very narrowly. So they're saying our protection, our immunity protection, should have extended to following the dependency court's directives on not letting people visit, not letting people communicate. But the judge didn't agree with that.
Well, yeah, because the court didn't even say that. The court actually said she should have visitation, and they were refusing to give it to her. Kathy Beatty was working on her own behalf, or I don't know, as an employee of Johns Hopkins to keep her mother from having the visitation she was court ordered to have. So, yeah.
Well, they're not complete monsters. So they say, to be clear, the defendant is not maintaining that statutory immunity would give it free pass to torture a child or place a child in a dungeon.
Oh, thank God.
But acts like placing Maya Kawalski in an ordinary hospital room to be video recorded to confirm whether her actions are consistent with CRPS should be acts for which the defendant has immunity.
Oh,
now,
really?
My deal with this is, my takeaway from this was not that they said, oh my God, she has CRPS. You're saying she has CRPS. Let's put her in this room and see if she has CRPS. Let's watch her on video. It seems to me they put the video in there to disprove that she had CRPS, not to see whether her actions were consistent. They put her in there to prove that her actions were inconsistent with it.
And notice how they're leaving out the stuff they did to nurses dancing around her, nurses slapping her, touching her, squeezing her, doing things to disprove that she was in pain. They left out all of that. They left out leaving the commode further away from her so that she had to
that's in here. They explain that in here.
They just deny it. They just deny that they did that for that reason. Yeah. But I think
So
we all
too,
know.
they're saying the immunity should be increased, should have been expanded to also so too should the acts of keeping the child in the hospital when the defendant expects that the dependency proceeding would be filed imminently. Now, photographs were just taken to document her skin condition before she left for court, where her skin could be affected, should be immune. They're saying we didn't do she was going to court. Her skin could have been affected by going to court. So we just wanted to take pictures of her before she went to court. So we should have immunity for doing that.
I mean, what even was their reason for this? Because they thought she was going to go to court, scratch herself up, and then come back and say what? I mean, it doesn't even make sense. I don't even know why they did that. What do you mean her skin could be affected in court? She's supervised by somebody.
Well, but after the entry of the shelter order, the parents' rights to make medical decisions did not extend to demanding ketamine infusions for their daughter. The Kowalskis and their attorneys could have filed an emergency petition to try to convince the dependency court that it should authorize such treatments, but it didn't. Now, a judge, learning that this process was only being performed by a limited group of physicians, this is the ketamine infusions, there's even if they had gone to this, had applied for an emergency motion, a judge learning that this process that they're asking for was only being performed by limited groups of physicians, more as a matter of experimentation than as a treatment modality acceptable and appropriately by reasonably prudent similar healthcare providers, was very unlikely to resume high dosage ketamine infusions. So they're saying we didn't do anything because even if they would have gone and filed with the dependency court to try to convince them to allow these infusions to continue, a court would have gone, wait a minute, this is just human experimentation, and likely wouldn't have resumed it anyway. So the claims for intentional infliction of emotional distress would not be claims for which the defendant would be entitled to immunity if proven. The problem in this case is that conduct interrelated with or heavily affected by the rules and regulations imposed by the dependency court in DCR was often used to confuse the jury and to allow the admission of evidence that was not extreme and outrageous conduct intolerable in a civilized community. Again, they just used all of these interrelationships to confuse the jury. So the court, under the urging of the plaintiffs, transformed a statute giving the defendant a shield of immunity into a sword that was repeatedly used by plaintiffs' counsel. Objection 39 was used to prevent the jury hearing relevant and necessary testimony and evidence, including, for example, the December report of Dr. Sally Smith. The defendant believes this transcript will show instances where the court limited the evidence based on 39 on its own motion. The court repeatedly told the jury that the defendant was not responsible for Maya Kawalski's long stay in the hospital, but plaintiffs repeatedly presented witnesses or made statements in front of the jury about the child being trapped in the hospital.
But wait, if the jury came up with the idea that the hospital was responsible, that it's Shapiro and Hunter's fault that they didn't explain it properly, but even so, I don't think that that's something that had to be excluded totally. They were found liable for a lot of this stuff. And yes, it's undeniable that the hospital was responsible for separating her from her family. Period. They did it. Well, and that period of time before the dependency case started, that 7 days is what was at issue. So the jury had every right to say, yes, you kept her from her family for those days. You did that. You kept her imprisoned in the hospital. Nobody else. A judge didn't order it. Yeah. You did it.
Well, that was clear in the verdict when they were specifically limited to those 3 events where they weren't under the control of the evil court process, the dependency court, and that's why there was the 3 separate periods. And to say they were trapped during those is for the jury to decide were they trapped or not.
And the defense appears to be say that 7 days is no big deal. Oh, sorry.
Yeah,
all right,
you're back. Well,
the defense appears to be saying that 7 days is no big deal to a child and her parents, and I say it's a huge deal. I say it's worth $261 million. That's how big of a deal it is. Sorry, JHACH.
Well, essentially what they're saying here is we shouldn't be held liable. Our immunity should extend to cover those periods because we couldn't have let her go. And they're going to explain why here in just a minute. The jury, but before the jury clearly did not understand the nuances of immunity under the instructions given by the court. Well, then how about you ask for better instructions or submit your own instructions? I don't know if they did or not. But,
why didn't you explain the nuances then? If it was so nuanced, why didn't you do a better job instead of ASMR whispering about Maya's homecoming dress? Maya, did you go to homecoming? Did you go to homecoming?
Okay, reel it in, Megan. Reel it in. We're getting far afield. We're page 33 of 144. The limitations placed on this issue made it impossible for the defendant to keep the jury from being enraged about events and circumstances over which the defendant had no control and no legal responsibility. So we don't have any control of this, but you let them become enraged about this, and they hated us because we didn't have any control over these things. We should be given immunity, and we should be given a new trial. Well, given the size of the monetary awards, it appears to have affected all of the claims. The defendant submits that this court erred in failing to grant broader immunity to the defendants and in failing to permit a fuller explanation from the witnesses, including the DCF witnesses, about that lawsuit and its impact on the family. This error warrants a new trial.
What lawsuit? Is he talking about the $2.5 million settlement they got from Suncoast?
I'm not sure.
I think that's what he might be saying. Saying, well, they already got $2 million.
Well, if this judgment is not set aside, no hospital in Florida will be willing to keep a child in DCF custody in its facility once the child is ready to be discharged to foster care. Well, should they be? Should they be keeping someone in custody in a hospital if they're ready to be discharged to foster care? I don't know. Well, the court erred in allowing plaintiff's attorney to make the massive request for damages generated by per hour, per component closing argument, which affected every claim. The defendant filed a motion to limit the use of an improper closing argument based on a method that deceptively allowed plaintiff's counsel to suggest awards as reasonable awards when they are many times higher than the maximum legal range in which the jury was actually free to operate. Saying, hey, the jury went off the rails here. They went rogue. There's no legal justification for some of the amounts they awarded. This method can make an award exponentially higher. This is how they said you break down at an hourly wage, however many hours this happened over the course of a lifetime. This method can make an award exponentially higher than is appropriate. And in this case, plaintiff's counsel often use 12 to 14 hours per day at rates of $100 an hour to present with a straight face. Again, I highlighted this because that was with a straight face. That does not need to be in there. That's petty schoolyard bullshit, third grade. You say that with a straight face. I hate when they do that. So in this case, plaintiff's counsel often use 12 to 14 hours per day at rates of $100 an hour to present with a straight face aggregate damages many times higher than an amount a reasonable jury would award. For Maya Kawalski's claim, in the aggregate, plaintiff counsel divided non-economic damages into past and future claims for pain and suffering, and for mental anguish, and the loss of capacity to enjoy life. These separate claims were given an hourly value of $100 per hour. So they're saying these three different claims were each given $100 per hour. So essentially, they're being given a value of $300 per hour. And so the daily total damages, which was undisclosed to the jury, of $8,400 per day for a lifespan of 70.42 years. Well, standards be standards, I guess. And whether that is something that I think like some of these damage calculations is probably where they have the most reasonable chance to get a reduction, because it's not unheard of for judges to reduce the amounts awarded in the end. But even more shocking, giving Mr. Kowalski's life expectancy, plaintiff's counsel recommended $2,700 per day for Mr. Kowalski for a total of $26,640,862, but the jury gave him $50 million. So the plaintiff's counsel only said $26.6 million, but they gave him $50 million. That is more than $5,200 per day.
But they can do that, right? I mean, The jury can do
Yes.
that. If they feel that he is entitled to more, they are the ones making that call.
And they're asking they're just asking the judge to determine that was unreasonable and excessive. And that's what the judge will have to decide. That's more than $5,200 per day. And this is a big thing in personal injury claims and in awards like this, these lump sum payments. It is awarded in a lump sum, which will produce extensive income over his lifetime. If we get our money as we do every 2 weeks or every month, it comes in. But if you get $1 bajillion up front, you get to invest it, you get to earn interest. And so that actually grows the value of the award. And that's what they're talking about there. So even though it's only $5,200 per day, you get in a lump sum, and that lump sum earns a ton of money. So, and they said within about an hour,
don't kidnap little kids. I don't know. I don't know what to tell you, JHACH. Quit kidnapping kids.
This is somehow improper, they're arguing. Within about an hour of the commencement of deliberations, despite the fact that the jury needed to review an immense collection of exhibits introduced into evidence, but not shown by either party during the trial under the leadership of juror number 1, the jury was already asking the court to provide the documents and testimony that were used to support the huge aggregate award. Well, now, see, this is the thing. I take a little bit of exception with despite the fact that the jury needed to review an immense collection of exhibits. Need to? If they can't come up to a decision, if they all walk in and go, yeah, what do you think?
Is that required for them to look at every piece of evidence? Or if they've already decided based on the case they just saw, they may not only need to look at 2 or 3 things.
Yeah, exactly. So, yeah, that I take exception with that. You don't have to look over every single piece of evidence before you make your decision. You just walk in and go, okay, this clearly happened. Now let's get to the money. I don't have a problem with it. That's
totally allowed. That's totally allowed. The jury was not instructed before you come to a decision. You must read every 3,000 pages of documents we gave you. They would have been there for a month.
Yeah, but they're just saying they're complaining that within an hour, under the leadership of jury number 1, the jury was already asking for documents and testimony to support their aggregate award. Well, perhaps the case against you was just that clear cut.
That's how we
Sucks to be you.
That's how we saw it. We saw it as clear cut. We said from the beginning, this jury is going to be asking how many zeros. Every time they put up a defense witness, it was, how many more zeros should we add to that check? Because they were so unlikable. Yeah.
And everybody knew when they came back with a question. So what's the question? And it was, can we see that chart of the damages again? We're like, all right, they're done. Yeah, they're just trying to do the math.
Deciding how much to write the check for. Yeah.
Yeah.
And that's okay. They're allowed to do that. This is all a bunch of garbage. They are allowed to do that.
The award for Mr. Kawalski for past medical bills totaled $1.5 million, which clearly demonstrated that the jury duplicated damages. The award of $5 million for insurance fraud when plaintiff's counsel suggested $1 and has even given this court a proposed judgment for only $1 demonstrates that the jury was totally lost in passion and prejudice when considering the issues in this case.
I'm sorry, that's going to be the name of my book. It is. It has to be. Passion and prejudice. It's going to be fantastic.
So they're saying here, well, the plaintiff counsel he suggested only $1, and he even gave a draft judgment for only $1, but they gave $5 million for insurance fraud. Well, don't commit insurance fraud, and you don't have to worry about how much the jury verdict is.
How many people on that verdict, on that jury, have gotten insurance bills before that they had to fight, because something went wrong and someone put something in wrong, and they've had to sit and fight with insurance. And then to see the evidence that these fuckers actually billed for $500,000 for a thing that they now stand in front of me claiming she does not have. You sealed your fate. yes, they're going to award $5 million because they know how hard it was for Jack to fight through that insurance, and he's had to pay all of that, the stuff that wasn't covered for her disease that JHACH put her in a basic jail cell for. How dare they?
Well, simply put, Megan, this method was an artifice that misled the jury. A jury influenced by prejudice and passion has produced a verdict so unreliable that a new trial is needed on all issues. They're just so influenced by prejudice and passion, we have to just go back to square one.
If they get their new trial, they're not going to like the outcome. I'm telling you right now, there's no other way this ends.
The decision to grant the defendant's motion for directed verdict on the negligent training claim only at the very end of the trial allowed the jury to be confused and misled by irrelevant evidence that impacted many of the claims in this case. Again, the jury's just too dumb to figure it out for themselves. So, Judge, we got to go get a better jury, or you have to do it yourself. One of the two. At the beginning of the trial, Maya Kawalski also had a claim for negligent training. This claim, which was not eliminated until a directed verdict immediately before closing arguments, allowed the jury to hear extensive, confusing, and ultimately irrelevant evidence that misled the jury and prejudiced the defendant.
Jeff, look at Jillian's comment. Find a lawyer that doesn't have autism who laughs during closing. Yeah. He scoffed. He scoffed at her. He scoffed at children who lost their mother. Maybe get somebody who isn't Beavis and Butthead.
And you know, we talked about that when I was going on to it. Just that thing. It was disgusting, inappropriate. Ugh. But see, again, it's like, oh well, this is. I hate when people think jurors are stupid. If jurors don't, just because they don't reach the decision you wanted, well, again, as we've been saying, perhaps you should explain it better. And there was a directed verdict given, which that's why every time you make an objection and say motion to strike or you're sustained, you're assuming that the jury is going to forget what was said and not take it into consideration. And so how come every objection that was sustained by you was good, but when they just get rid of an entire section of the trial and go, okay, we're directing you to forget this, that's somehow not good enough and they're too dumb to figure it out in that case.
Also take into consideration that the judge did rule on several motions for verdict. He directed verdicts on several things in the defense's favor. Several things. So looking at the record, he did.
The jury's smart enough to figure those out. They're just not smart enough to figure this one out.
Yeah.
Did you put your microphone in the laundry machine?
Oh, I'm sorry. I had to plug my phone in.
Oh, okay.
So I had to take my headphones out. I'll stop talking while it charges.
I was just curious. It kind of sounded like that.
I'm sorry.
No worries.
It's because it's on speaker.
No worries. It was just like rustling against clothing or something. It doesn't matter. You're good now. This court correctly, albeit belatedly, granted a directed verdict. Okay. They're saying the court correctly gave the directed verdict. It was just late. By then, the damage had been done, and that damage is reflected throughout the jury's verdict. So now they're complaining that the court arrived at the right decision to give them a directed verdict, just because it was a little bit later than they wanted it.
On which issue? Which issue is that?
This was the negligent training issue.
Oh, gotcha. Well, that's okay because the jury just basically shoehorned it under medical malpractice because it is. It is. It's still malpractice.
We're not going to start that argument again. This error requires a new trial for the entire case, or at least for major portions of the claim made by Maya Kawalski and the estate. Now, the unfairness of giving the plaintiffs more time. They gave additional time to the plaintiffs. This case severely prejudiced the defendants.
I don't know how. I don't know how that would severely they got the same time. That was my favorite denial of Judge Carroll's. I made it into a thug judge meme when he said, let me get this straight. You're objecting to more time that I've given you, the same amount of time as I gave them, and you could also call those witnesses. You say that now you would, you wouldn't have the time or whatever. Yeah, denied. Yeah, that was stupid.
The judge was waiting for him to say, yes, that's exactly what we're saying. Just so he could do that.
And he did. He goes, yes. And the judge goes, yeah, denied.
Well, let's find out all about this, how severely prejudiced the defendants were because the plaintiffs got more time. The court granted the plaintiff additional time for its case on not one, but 2 occasions. Coupled with the inefficient manner in which plaintiff's counsel introduced evidence, exhibits, and the testimony of witnesses, these extensions placed the court behind on its timeline that required this case to end on November 9th. Yeah, because the plaintiffs, they don't know how to introduce exhibits and or testimony. They delayed it and they got more time, and we had to end it on November 9th.
He's just mad. Shapiro's just mad he missed his vacation. Yeah, he's mad that he missed his Disney cruise.
Well, the defendant knew it had time, but no remaining days to present more witnesses. Or, for example, to present several hours of the video from the room on the 7th floor that contained video and EEG equipment.
They were going to make us watch several hours of that?
Oh, yes, and clearly, if you would have been able to watch these several hours of this, you would have seen that there was no CRPS going on. You would have seen there was nothing.
There was no CRPS going on.
You would have seen it, Megan. They promise. They had the time to do it, but they didn't have any days because the plaintiffs got a couple more hours.
Well, they all got a couple more hours. It wasn't just awarded to the plaintiffs. It was also awarded to the defense. Not to mention that we had this discussion back when this was happening. All the lawyers agreed. No judge in his right mind is going to cut off the plaintiff and say, no, well, you're done. You've run out of time. And so now the defense gets to just, you don't get to respond to anything the defense can put in. That's absurd. That wouldn't happen. And so they have to extend if it comes to the point when they need to extend, if somebody's running out of time. He didn't go overboard. He gave them 4 hours. Big deal.
Well, we're about to go overboard in their criticism of Dr. Eli Neuberger.
Oh, I hate this part.
But before we do that, we have super chats here. Let's clear through these super chats before we move on to the next section, sort of a little palate cleanser. Leah G. Banger, Hope Hunter and Shapiro have heard of karma, D-heads. Thank you, Leah. And Nicholas Starov being irreverent. Weird. That's the sound I hear when phone intimacy with a girlfriend. Can't hear a thing after she puts it in. Thank you so much, Nicholas, for that comment, I think. Julie O has been a member for 14 months. All I can hear is Jesse on Saved by the Bell. There's no time. There's never any time. Wow. There's no time. All right. Well, folks, let's move on to this next section because this annoyed me. This annoyed me far more than most of the other parts of this annoyed me.
You know what's funny about this, though?
What's that?
Just Dr. Neuberger kicked their ass from a recorded deposition while he was in a hospital. He kicked their ass while he was severely sick in a hospital with just his recorded deposition. He kicked their ass. Good job, Dr. Neuberger.
Well, see, notice how much problem they have with what he said versus who said it. Do a little balancing as we go through this testimony. Dr. Neuberger is an elderly physician. How freaking condescending is that?
Oh, and that's not the first time they'll say it.
No, that gets worse. Like, in case you don't know what an elderly physician is, he graduated from medical school in 1966. And he gained his first experience in the Vietnam freaking War. So so instead of saying, holy crap, this guy graduated from medical school 3 years before my 54-year-old ass was on this planet, so he must have an absolute F ton of experience. Oh, they're going, he's just a doddering old Bruce Willis at this point in his life. He's just this doddering old guy that, good Lord, the World War II was barely over when he graduated.
Prejudice. Talk about
seriously.
Prejudice. Isn't this is ageism? So they're ageist
In
now.
its highest form. And this is literally like that's how they begin their criticism of what he said. Or do they really criticize what he said, or is it just who said it?
No, they really don't.
He's an elderly physician.
They're just calling names.
Yeah. When younger, he taught at Harvard Medical School and served on the staff of Boston Children's Hospital. But this isn't the first time they go after him, by the way. They do it later on in the motion, too. But he retired at the end of 1999 and never had an actual pediatric practice. To be clear, the defendant does not question Dr. Neuberger's qualifications to express opinions despite his age.
Oh,
Old people aren't entitled to opinions anymore, according to the defense.
Despite his age. Oh, oof.
Even though he's an old mother effer, he still gets to answer questions and have an opinion about things. I mean, good Lord, they actually said this in a deposition. I mean, in a motion submitted to the court.
This is so bad. How old is Mr. Altenburn?
The defendant does.
I bet he's similar to
he's
age.
so old. He was a judge when the judge was 16 years old. That's how old he is.
And not just a judge, he was on the appellate court, which means he had been a trial judge before then somewhere. So, I mean, my God.
But I can't. I just can't even imagine that they would put something that offensive into this motion. Dr. Neuberger's qualifications. We do not question his qualifications to express opinions despite his age and limited recent experience.
What limited recent experience is why? Because he's retired, because he's not practicing. That does not erase your years of experience and knowledge. You absolute waste of human space. I hate these people. They have made me just despise them the way they write. How could you write about someone like this?
Well, okay, I didn't highlight this part, but let's roll this back just because you raised that point. They say he retired at the end of 1999 and never had any actual pediatric practice. So they go, okay, this guy was put out to pasture in the last millennium.
That's
and he's
actually
never
not true that he had.
But
no
no,
pediatric
I know. Hang on, Megan. Let me finish. They're saying he retired and he never had any actual pediatric practice. But then they go down here and they say since 1999. Well, wait, I thought he retired in 1990. Well, he's been doing something since 1999. What has he been doing? His consultations in child abuse pediatrics have been a sustaining source of income. Oh, wait a minute. So he's actually still been doing stuff dealing with child abuse pediatrics for the last 23 years, not retired and just futtering around on a golf course somewhere.
If you guys want to read about Dr. Neuberger's unbelievable background, you need to look at my article on pjmedia.com about him. I wrote it early on in the trial when he testified, and I put his background in there. His amount of experience that he had with abused children is mind-blowing, what this man did. He traveled the world. He helped people create the new ways of looking at how to help abused children. This man has an impeccable resume. It's impeccable.
Well, now
go and read about it on pjmedia.com on my article about Dr. Neuberger, because it's fascinating. He's a fascinating person.
Now, Megan, I'm going to read what I consider to be the most offensive sentence in this entire 144-page motion.
Oh, wow. This should be good.
Apologies out there for sensitive folks. I'm going to use a cursey word. This next sentence made me lose my shit. All right, we'll let you all in chat decide how offensive this is. So anyway, to be clear, the defendant does not question Dr. Newberger's qualifications to express opinions despite his age and limited recent experience. He would have been well qualified to testify for Beata Kowalski had she chosen not to commit suicide and instead had gone to trial in February 2017 in the dependency court.
Ugh.
He would have been well qualified to testify for if she hadn't chosen to commit suicide and had gone to trial instead.
Oh my God.
I find that to be the most offensive sentence in this entire thing.
Especially because, Jeff, you and I have been reading through the dependency hearings.
Yes.
And what do you think that judge was going to do at that trial? Was he in any way paying any attention to the family's attorneys?
Not really.
Or their witnesses? He wasn't. He was ruling with the hospital and DCF every step of the way. Every step of the way. The idea that, if she hadn't killed herself, Dr. Newberger could have got her off at trial.
Oh, we can't hear you. Your microphone is covered again.
Oh, sorry.
There we go.
It's absurd that if they had just had Dr. Newberger go testify for them at that dependency hearing, that he could have gotten them all off and it would have been fine. No, I don't think so. Not from what I read in those dependency hearings. That judge was not persuaded at all by the family's witnesses. Mm-hmm. So I'm just saying this is garbage anyway.
Yeah, but this was from Mr. Hunter. He apparently would signed off on this. He would have been well qualified to testify for Beata Kowalski had she chosen not to commit suicide and instead gone to trial in February. That's disgusting.
The mishmash says, I just lost my mind. Every time I think they can't shock me anymore. Yep.
That's just a disgusting sentence to me. And they should be ashamed for, I mean, that should be a badge of shame for the rest of their careers to have put that on paper and signed off and thought that would be a really nice thing to say. Continuing on.
I just feel sick.
Yeah.
That just makes me feel sick. And especially because they wrote these words knowing that the plaintiff was going to read them, knowing that Jack is going to read that, knowing that Maya is going to read that. It just, they don't care. They're scum.
After the plaintiff withdrew any claim concerning Munchausen's by proxy, the subject of child abuse had little or no relevance in this case. Dr. Newberger was allowed to become a jack-of-all-trades expert who opined on unlawful acts and conspiracy of the doctors of Johns Hopkins All Children's Hospital, a conspiracy headed up by Dr. Sally Smith. The court allowed Dr.
If the shoe fits. If the shoe fits.
I swore I was never going to go ugh again, but I've done it so much in the last 2 days. The court allowed Dr. Newberger to describe the medical team, including Dr. Sally Smith, as conspirators acting on the basis of a flimsy notion, performing acts preposterously conceived and cruelly executed.
Yeah, that was several times when Dr. Newberger said it. It was a beautiful sentence. It was
is there a problem with it? Do we have a problem with that sentence?
No, it's absolutely correct. It was cruelly conceived, preposterously conceived, and cruelly executed. That was a wonderful sentence. This man has a way with words. He's a national treasure.
Mm-hmm. This is an opinion from a doctor qualified to render child abuse opinions who is challenging the work of a board-certified anesthesiologist, pain management physician concerning medical decisions well beyond the expertise he had even in 1999.
They're underestimating his experience, by the way. He is board certified. He's board certified not with child abuse pediatrics because he said it was bullshit. and he didn't want anything to do with that certification. He got his certification through an emeritus. I can't remember which one it was, but it's another very highly respected certification. And he has all kinds of experience in psychology, child psychiatry, in family dynamics. This man has a background like you would not believe. You would want this man for any case like this. He is
But
the
wait,
best witness.
there's more. Moreover, it should be observed that this elderly doctor was also very confused about the basic facts expressed in his opinion. The child's port was never removed in the hospital. Beata Kowalski refused to follow the advice of the doctors who were actually treating Maya Kowalski.
No, they
It was
just
not
didn't clean
Dr.
it.
Smith. Yeah.
They just
It was
didn't
not
clean
Dr.
it.
Smith who asked her to consent to its removal. A third example, Dr. Newberger's ability to testify that she's not faking it based on all the CRPS symptomology that's been documented at this time, which Smith couldn't get her head around or wouldn't. He is not an expert in CRPS. Was Smith? Was she an expert on CRPS? Had she even heard of CRPS until long after she started talking to Maya?
No, and they didn't get any CRPS expert at Johns Hopkins to look at her either.
He's providing an opinion about Dr. Smith's opinions as the CPT leader that were in her report, which this court excluded from evidence. Yeah, so they're complaining that the alleged non-expert on CRPS was providing an opinion about someone who'd never even heard of the illness, filed a report, and was investigating them for child abuse. Well, with regard to the impact on this family of Dr. Smith and the other Johns Hopkins, this is a quote quoting here. The judge allowed the jury to hear this improperly, apparently. With regard to the impact of this family of Dr. Smiths and other Johns Hopkins All Children's Hospital workers, they have been more deeply informed with regard to the trauma suffered by the girl and her father, with regard to their impact in propelling the mother's taking her own life, with regard to the following impacts on the child of the trauma, which have produced an acute and concerning medical set of consequences that derive directly, in my opinion, from the malfeasance of the hospital staff, from the staff of the hospital. So, I think I don't have a problem with that. I don't have a problem with him saying that personally.
No, I don't either. I think he was absolutely correct. He's absolutely correct. The malfeasance of the staff of the hospital. There is tons of evidence that they were negligent toward her in her care.
This is not expert testimony, says the argument. It's the plaintiff's closing arguments for the claim of intentional infliction of emotional distress causing death by suicide. There's no factual basis in the record to support any of this conspiracy theory. Only the clearly inadmissible opinion that thoroughly intermingles and conflates Chapter 39 proceeding with his lawsuit. The magnitude of this error is hard to measure. There's that hyperbolic language again that you go, well, hard to measure? Is it really? Why are you talking like this? But the jury clearly measured it in dollars.
That was their job.
Exactly. Again, this is one thing that we talk about. There is no judgment on planet Earth that will restore that family to how they were before JHACH got involved in their life. There is nothing that a jury, judge, or anyone else on Earth can do to put them in that same position. The only thing we do, and it is admittedly flawed and improper, well, not improper, it's flawed and, what's the word I'm looking, insufficient. It's flawed and insufficient, but the only remedy in situations like this is to affix a dollar value to the damage that occurred. That is literally, as Megan said, their job.
And the punitive damages is actually to punish the hospital so that they never do this again. And so on one hand, they're trying to make the family whole, which can never be done. But on the other hand, also trying to punish for the bad behavior.
And they're arguing here that this error led them to award this ridiculously inflated amount. So we need a new trial on every claim. Well, what about the intentional tort claim of Maya Kawalski? At the end of the trial, Maya Kawalski had 4 claims that were submitted to the jury: false imprisonment, battery, medical negligence, and intentional infliction of emotional distress. These claims overlapped repeatedly concerning both evidence for liability and damages. The court twice told the jury in the jury instructions that although these claims have been tried together, each is separate from the other. It also reminded the jury not to let bias, sympathy, or prejudice influence its decision. The court provided an instruction on non-duplication of damages. Here's a question for you, Megan. What if the jury actually listened and did that? What if they followed the judge's instructions?
I think they did.
Well, the defense disagrees with you. They think the only way they could have arrived at these ridiculous numbers is if they ignored or didn't understand, because they're too dumb, the judge's instructions. And they're going to tell you all about this. The verdict, both as to liability and damages, is the product of plaintiff's strategy to create sympathy for Maya Kawalski that would overcome the law, to place responsibility on this defendant for Dr. Sally Smith, the Department of Children and Families, and the court system for taking her away from her mother. That's the plaintiff's evil plan, is to hold them accountable. There's the false imprisonment claims.
Well,
the first one,
that's what court is for. That's what court is for. You take so that we don't have vigilante justice. We have court systems so that you can take someone who wronged you before a judge and a jury and work out your dispute. Yeah. That's what it's for. This is like, do they not know the basics of what lawsuits are for?
Well, false imprisonment. There was no false imprisonment. They're going to tell you why. And certainly not why it wasn't worth a heavy amount of damages. They're going to tell you. They're going to answer all your questions. But before they do, there's a couple of super chats we should get through here.
I just got one too. Thank
Hunter,
you, Amy,
cool.
for sending me a Venmo. I appreciate that.
Hunter Rose the Dracula. The Dracula is not going away. Julie O gifted 5 Legal Vices memberships. Thank you so much, Julie O, for that. If you got one of those 5 Legal Vices memberships, give her a super special thanks. Thank you. You're such a good supporter. Thank you so much, Julie O. And Vermillionaire, member for 8 months, miserable and bad as this was for the family. At least the world can see how powerful companies treat small people. These lawyers should be ashamed.
That's a very good point. This is really showing what I've been told happens to everybody, but this is one of the first times that the public is getting to see how hospitals treat people who claim medical negligence. So, yeah, that's a big deal. The mask has been ripped off.
I mean, see, this as a lawyer, I can stand and say that JHACH has the right to put on a vigorous defense of their position. They have a right to have lawyers put these arguments together and use every means available and make every argument possible for them. But you still have to be able to look at yourself in the mirror in the morning. And putting this, well, if the little girl's mother had chosen not to commit suicide and had gone to trial, this might be different. Or, this guy that said a lot of really important things, well, he graduated from medical school in 1966. He's this old, doddering, confused man. See, you can make these arguments without stooping to that level, and God forbid conceding when you know you don't have a legitimate way out of this argument, when you know that it was a fair and reasonable judgment. So, I mean, they're entitled to make these defenses. They're entitled to make these appeals. They're entitled to make these motions. But when you do them, you still have to look at what you've put down on that paper and signed your name to, and look at yourself in the morning and decide whether you still have a soul or not.
There was a way to write this that did not further outrage the public.
Yeah.
There was a way to write this to just stay very factual about how you thought the punitive damages were too much or whatever, and you need some reductions or whatever. You did not have to put in this stuff about Beata. You didn't have to put in this stuff about Dr. Neuberger being too old to have an opinion. This is just, there's something wrong with these people. They are the dick defense. They can't help themselves. It's just who they are.
Well, there's a very good interview out there on YouTube by Jerry Spence, who was one of the greatest defense lawyers that ever lived. I mean, one of the greatest lawyers that ever lived. As a prosecutor, he never lost a case. As a defense lawyer, he never lost a case. he's never basically since like 1960 some odd.
Wow, that's impressive.
But yeah, I mean, and he's defended Imelda Marcos, and I mean others. You know, Karen Silkwood. He helped her case. He was her lawyer, but the guy's never lost a case basically. And he went from being an insurance guy to whose legal job was to make sure people didn't get money they were probably entitled to. When he had a trial, he made the claimant look like a fool on the stand, and basically made sure the guy got no compensation whatsoever for his injuries. And it was either the day of or the day after, shortly thereafter, he was standing in front of the claimant in a grocery store checkout line. And the guy said, he shook his hand and said, "I don't have any grudge against you. You were just doing your job." And he basically said he had to go home, look in the mirror and go, "Is this the job I want to keep doing?" He couldn't look at himself in the mirror anymore. So, can these guys put this stuff on paper, continue to look at themselves in the mirror and think, that was a very, very professionally crafted, legally sound document I submitted to that court? I got problems with it.
So much of it is so petty and yeah, cruel. Speak Life Garden Homestead and Permaculture says petty and cruel. It is. It does come across that way. And they didn't have to write it this way. There is a way to write a motion for exactly what they wanted here without making these outrageous and offensive statements.
Well, let's take a look at the claim for false imprisonment from October 7 to 13, shall we? When she was in the intensive care unit for approximately 6 days. The plaintiff's theory is that the doctors were unreasonable and unwarranted in failing to roll Maya Kawalski out of the intensive care unit in her wheelchair and place her in her mother's car to take her home one or more times during this period. Her mother was a nurse infusionist, and Maya Kawalski had a port installed in her body to allow for easy infusion. It was disputed whether the doctors or some unidentified security guard threatened to arrest the parents if they removed their daughter from the hospital. It is undisputed that the doctors contacted Dr. Sally Smith about this situation. Dr. Smith had staff privileges at the hospital and was also known to be the board-certified pediatrician in charge of the state's CPT team in this zone. She had expertise in medical child abuse and the factors to consider when deciding to report a matter to the abuse hotline. After consulting with her, the defendant made 2 calls to report possible abuse to the hotline. The second call was when Beata Kowalski was apparently wanting to take her daughter home, and DCF acted on that call. Dr. Smith conducted an investigation for DCF during this period. There's the background information. Well, one nurse apparently did a transfer from one bed to another that was rough. She may have been dropped in this move. I mean, for intercourse sake. You just
Did they really say that?
Yes.
Oh my God!
Yes.
Look at this.
What?
She may have been dropped. Holy crap!
But there's no evidence of injury requiring treatment. Indeed, there's no evidence that she sustained any physical injury from this imprisonment.
I don't even think we heard this during the trial, Jeff. I don't think this even came out. So now they're admitting to stuff that never came up in the trial. They dropped her? We never heard this before.
May have. She may have been dropped in this move, it says.
Oh my God! Oh my God! What?
So you can say, the move, the transfer from one bed to another may have been rough. And by rough, they mean dropped her. Yeah, that's rough. But again, there's no evidence of injury requiring treatment. There's no evidence she sustained any physical injury from this imprisonment. I hate to tell you this, but whether or not someone suffers injury is not the standard of determining whether there was any improper or imprisonment going on here.
Malpractice, perhaps. Negligent
See, this is false
care.
This is false imprisonment. That I don't see with injury or false injurious imprisonment or injured false. No, it's just false imprisonment. Did they have the legal grounds to do what they not? Why this is even part of it is, I mean, it makes no sense to me. They're saying because she wasn't injured, she wasn't imprisoned.
I can't believe they wrote that in there. She was transferred from one bed to another. That was rough. Well, there's your medical malpractice. Why is that's not a standard of care to drop your patients from bed to bed?
There may be evidence of claimed medical negligence during this period due to the unwillingness of the doctors to accept the diagnosis of CRPS as definitive and to begin treatment with a ketamine infusion. But that is not part of the intentional tort of false imprisonment. So why talk about it?
Oh, wait, Jeff.
What?
So they're literally saying here, there's evidence of medical negligence, but it's not part of false imprisonment. But
yes.
Didn't they just say they wanted a new trial on the medical negligence too?
You're not supposed to compare different sections, Megan. Shh. You're supposed to forget about because they don't want you to. They don't want you to.
But my God, how can they do this? How can they say in one section, well, yeah, there was medical negligence, but it's not part of this one. So, and then in the medical negligence section, they're going to be like, there's no medical negligence. You can't prove that. Now
the renewed motion for a directed verdict and motion for a new trial based on a verdict against the manifest weight of the evidence. This is going to take forever. We got to find a way to speed this up because we're 2 hours in and we're not even halfway through this 144-page motion.
Okay, I'm going to be quiet.
I mean, there's a lot to get through, but we're going to see these same things repeated over and over again. So we can probably skip some of these again. The manifest weight of the evidence.
Do you want to do part 2 tomorrow? We could do part 2 tomorrow, maybe.
That's something we're definitely going to keep in mind. See how much we can get through here, because I have to be awake in like 4.5 hours. So
I know.
We'll see how we get going. Let's see how much we can get through here. But the renewed motion for a directed verdict and motion for new trial based on a verdict against the manifest weight of the evidence. Again, very basically put into normal people terms. Yeah, there was some evidence this happened, but there was the manifest weight, the enormous weight of evidence is on the other side of this didn't happen. So you should just say, okay, never mind. We're going to set aside the jury verdict and we're going to give it to the defense because the manifest weight of the evidence is on their side. So in the defendant's position, it is the defendant's position that at the end of the case, it was entitled to a directed verdict. Because even assuming that the Kowalskis were demanding to take their daughter home at the time, Maya Kawalski was in no condition to leave the hospital, and the Kowalskis had no arrangements to transfer her to another facility. The plaintiff did not establish that the defendant's decision to decline her release to allow her to go home was either unreasonable or unwarranted given the condition of Maya Kawalski at the time, as well as the mindset of her mother. It would have been unreasonable and unwarranted to send the child home under those conditions. So we don't know what's going to happen after she leaves here, so it would be unreasonable if we send her home. While not raised with a jury due to its complexity, the defendant also had immunity under Chapter 39 for at least 24 hours of this period, and should have immunity for this claim from the point it made the hotline call. Well, that's interesting. While not raised with the jury due to its complexity, well, they didn't raise it. They're saying that it was even shorter than this period, but we just didn't talk about that because it was too confusing for the jury to understand.
Well, that's their fault.
Yeah, maybe next time. Exactly. Maybe next time make the argument. And you didn't talk about it during the trial, so why are you talking about it in the motion now? There was no question of fact to present to the jury on whether keeping this child in the emergency room or in the pediatric intensive care unit was unreasonable or unwarranted, when the parents had no plan except to take her home where her mother could have infused her with anything. We don't know what the mother was going to put in her body, so how can we let her go?
We actually do. We actually do know, because there are prescriptions. We actually do know, and it was nothing she wasn't supposed to be giving her.
But she could give her something she wasn't supposed to give her. We don't know.
If she could have given her ketamine at home, why would she take her to the goddamn hospital?
She could have given her bleach through that port, though, Megan. So therefore, we should never, under this standard, where her mother could have infused her with anything, we should never, ever, ever let anyone ever leave a hospital ever again, because we don't know what's going to happen when they go out the door.
They had no evidence that Beata Kowalski was doing any of the sort. They made that up. They made it up. They knew damn well that the ketamine was oral ketamine that she was being given. They knew that. They made it up that she was possibly giving her ketamine through the port. Ridiculous. These people.
And then even if the defendant's not entitled to a renewed directed verdict, the jury's verdict is clearly against the manifest weight of the evidence. The sheer speculation by the plaintiff that the doctors hatched a plan to imprison Maya Kawalski when the truth is that her treating physician sent her to the hospital for emergency treatment, it's not worthy of this court's acceptance, even though it appears to have misled the jury. And then you gave him too much money, by the way, Judge, so we need a new trial because the jury gave him too much money. The jury awarded Maya Kawalski $2.496 million for medical care and psychological expenses in the future. Had this claim been tried separately, it's inconceivable that a jury would have returned this verdict. So if they just would have had a separate trial for this one issue, there's no way they would have come back with $2.5 million.
I disagree. I think they would have come back with 4.5.
But in addition to these awards, the jury awarded $3 million in non-economic damages for this event, for an event that did not involve any of the usual facts of false imprisonment. She was not locked in a dark closet. She was cared for in an intensive care unit.
Oh, where they dropped her? She was cared for where they dropped her? Yeah.
Even 10% of this amount would be excessive. That's what they're saying. And so then we get down here.
They just admitted that they roughly transferred her and dropped her. And then they're saying there's nothing terrible about this. She was well cared for while we were dropping her. Yeah. So
the jury awarded $3 million, but they're saying there's no evidence to support the actual award for 2.49. Defendant submits that the maximum lawful range for future economic damages for these few days of hospitalization would be perhaps $6,000. So don't give him the 2.5 million. Give him 6,000.
Wow.
It's an event she doesn't even remember well. Somehow that makes it okay. She doesn't remember it. Renewed motion for directed verdict on these punitive damages. Remember the punitive damages or a new trial, et cetera, et cetera. This is the question that they ask after every single issue here. Where is the clear and convincing evidence that any of them had actual knowledge of the wrongfulness of their conduct and the high probability that injury would result? And despite that knowledge, they intentionally pursued this course. Where is this evidence?
This might be a good place, Jeff, to talk about clear and convincing evidence versus a criminal standard, which is beyond a reasonable doubt. Clear and convincing evidence is a lower standard than that. So what's the definition of clear and convincing evidence?
Oh my, do we want to get sidetracked on that?
Well, I think it's important. Well, I think it's important because what I feel like he's arguing is a beyond a reasonable doubt. And what the standard really is in civil court is clear and convincing, which is much different. It's
the 51% standard. It's more likely than not.
Okay, so there it is. Yeah. So the jury has the ability to determine if it was more likely that this stuff happened than not, and they did.
I'm sorry, that
would
be
beyond a reasonable doubt.
Highly and substantially more likely to be true than untrue.
Right.
The preponderance of the evidence is 51%.
That is much lower standard of evidence than beyond a reasonable doubt, which is what it appears that he is trying to argue. He's saying, show me the facts, show me the evidence. Where's this list of things, which I believe I have been making throughout this stream, a list of things that convinced the jury that your hospital did these things, that it was more likely that they did.
Well, there's more likely than not. That's the preponderance of the evidence. Above that is clear and convincing, which is highly and substantially more likely to be true than not. And then there's beyond a reasonable doubt, way above it.
Yeah. Right. Okay. So
let's say 70, 75%. 70, 75%.
Okay. So we're going up from 51 to like 75% more likely. Okay. Substantially. Still, I think they met it. And this is not a reasonable doubt.
That's just the refrain. Yeah. That's just the refrain they keep asking through the whole thing is where is the evidence? Where is the clear and convincing evidence that any of them knew it was wrong, knew injury would happen, and did it anyway to cause the injury? And where is the clear and convincing evidence that any of them were so reckless or wanting in care that it constituted conscious disregard? They kept a child in a hospital when she needed hospital care, as sought by her treating physician when her mother wanted to take her home. That was indifference to her life and safety by clear and convincing evidence? ? If this court does not grant a directed verdict, then the defendant is clearly entitled to a new trial because the manifest weight of the evidence doesn't support the verdict. Then they make a motion for a new trial on the punitive damages. They awarded $15 million. This is more than juries typically award as punitive damages for a slow, painful death in tobacco case. It is a patent demonstration that this jury, under the leadership of juror number 1, and the arguments of plaintiff's counsel, was overwhelmed by improper passion and prejudice.
Dun, dun, dun. Every time they say juror number 1, I think we should have a dun,
Under
dun,
the
dun.
leadership. Again, that leadership of a jury foreman. Anyway, we've pounded that particular thing into the dirt enough. We don't need to go back over that.
Yeah, we can move on.
They were just so overwhelmed by the arguments of plaintiff's counsel and the leadership of juror number 1 that they just all got the vapors and they were overwhelmed by improper passions and prejudice. These findings are once again clear proof that this jury made repeated errors of great magnitude due to prejudice and passion. Is that seriously going to be the title of your next book?
Yep.
Or should it be improper prejudice and passion?
It's going to be passion and prejudice.
So
that's what it's going to be called.
This $15 million
the Maya
award.
Kawalski story. Passion and prejudice. The Maya Kawalski story.
This $15 million award, they say, well, this huge punitive damage should be more about $18,000. So take it down from 15 to 18,000. 15 million, right out, 18,000. That's what we think is reasonable. And then the 2-day, October 18th to October 20th false imprisonment. Same thing. When in this room, Maya was video recorded without her knowledge. This was done as a test to see if she would engage in activities that were consistent or inconsistent with CRPS when she was not aware that anyone was observing her. So, again, I don't recall...
No medical purpose. No medical purpose.
We were doing it to see whether or not she had it. The way I saw all of the evidence presented was that they were doing this specifically to try to prove she didn't have it. That's
yes.
Let's not do this. Let's not take her to the restroom. Let's put this a little bit further out of the way. Let's not do these things so that we can force her to do it on herself to catch her. That actually Smith was it Smith or Beatty? It was Smith that actually used that in one of these to try to catch her, wasn't it? Somebody used that.
It was in the notes. It was in the notes on the of the risk management notes to catch her.
That doesn't sound like someone saying we want to watch and observe her to do a differential to see if she's exhibiting any of these signs. No, that's specifically saying you are trying to prove that they are lying to you.
Also, please notice that this decision was made by Dr. Paula Dees. Dr. Sally Smith also wanted this testing done for the DCF proceeding. They denied that this was done at the direction of Sally Smith during the trial. So here we have more evidence that they're now backtracking on what they said during trial.
This process was not actually treatment of Maya Kawalski. It was a test.
And there it is.
Primarily non-invasive diagnostic test.
They just said it wasn't treatment. So it had no medical purpose. It was not treatment. This is medical negligence right here.
Well, they're saying the medical reasoning was it was a test, it was a diagnostics, it was differential. Yeah, if she engaged in actions that are completely inconsistent with CRPS, then the diagnosis can be rejected or at least highly questioned. They were trying to catch her out and be a liar. This is just
but they didn't catch her doing anything that was inconsistent with CRPS. But they still, after this, did not change their approach to her and did not start treating her for CRPS, and they didn't give her back to her parents. So this is not
this was not what they said it was, because if it had been, they would have said, oops, we were wrong, but they didn't. They continued on.
They make a small little kind of admission here in this next section. The doctors did not obtain a separate and specific consent of the parents to move their child to this room for the test. But in retrospect, at least Mr. Kowalski could have been informed of the test if he'd made sure that no one told Maya. But this is still not a treatment or an invasive test of the sort which consent is necessary. But we probably should have told him, but yeah. But this wasn't really something that required his, consent. We're just taking his daughter into another room and videotaping her.
Your opinion, man.
She claimed at trial that she was imprisoned, but in the video recording, she shows no signs of thinking she was imprisoned. This child probably wanted to go home every day she was in the hospital, but that was a decision for the dependency court, not this defendant. What's a sign of thinking she's being imprisoned? Please, sir, may I have some more? I mean,
Except also, when he says that was for the dependency court to make, well, then why was JHACH, why was Mr. Hunter in front of the dependency court arguing to keep her away from her parents then? Why was he fighting on behalf of DCF and the state to keep her thousands of miles away from her parents? I realize that doesn't come into it because the jury doesn't know that, but look at how they lie. And that wasn't for us to decide. That was for the dependency court. Meanwhile, he's in dependency court fighting for that very thing.
Well, let's ask the rhetorical question. If she wasn't being imprisoned, what would happen if Jack went in there and said, all right, we're going home now?
Right. He was threatened with police. Yeah. He was threatened that he would be arrested if he tried that. Yeah.
Now, again, the manifest weight of the evidence is against the jury verdict. It's the defendant's position that it was entitled to a directed verdict at the end of plaintiff's case. And now, because the videotape is conclusive evidence that Maya Kawalski was not falsely imprisoned, or that she even thought she was falsely imprisoned at the time. The jury's verdict is clearly against the manifest weight of the evidence. Both the defendant's employees and the videotape itself very clearly provide more than manifest weight of evidence that no imprisonment occurred. Was she free to walk out the door? Yes or no?
Nope. She also was kept from even talking to other patients. So there's plenty of evidence that she was falsely imprisoned.
Admittedly, the entire hospitalization on the 7th floor may have been against her will, but the dependency court and not this defendant is responsible for that stay. The jury simply could not sort out the acts for which the defendant was responsible from those from which it had total immunity. Or maybe they very clearly came to the decision that from point A to point B, you were in charge. From point B to point C, they were in charge, etc., etc. Maybe they're not stupid. Just a theory I have.
The Dick defense thinks everybody's stupid.
Well, yeah, that's that's kind of like that little deal where if you've got 90 people in the room and 89 of them are assholes, that kind of tells you what's going on.
Yeah,
there's too many. You awarded too many damages for this quote unquote false imprisonment for 2 days. Maya gets $1.4 million for medical care and psychological expenses in the future! Exclamation point. There is no evidence in the record that this event required medical treatment or psychological treatment even in the past. Mr. Kowalski is awarded $561,000 in past medical expenses for the care of injuries caused by this event. The jury awarded another $3 million in non-economic damages for this event. Even a verdict of 1% of this amount, $30,000, would be excessive. This requires a new trial. So they say, well, the defendant submits that the maximum lawful range for future economic damages from these 2 days of hospitalization, during which she did have nursing care and physical therapy, as demonstrated by the plaintiff's evidence.
Nursing care that may have dropped her. Mm-hmm.
And did leave the room, and she slept normally, as demonstrated by the videotape, would be less than $5,000. The past and future non-economic damages for an event that caused her no physical injuries requiring treatment at the time might somehow be worth another $10,000, but there is no evidence to support $1.4 million. So, again, where is all this clear and convincing evidence of of intentional act or gross negligence. The video demonstrates that her life, safety, and rights are a little different in this room than in the room in which she stayed before and after the test. So we think that she should get $45,000. That's their idea.
I can't even. I just can't even.
What about 1 day of false imprisonment on January 6th? Well, immunity aside, this claim involves Maya Kawalski's testimony that she was placed in a room for a few minutes and photographed in her shorts and bra prior to being placed in the hospital, to be released from the hospital to go to court to see Dr. Duncan and Dr. Hannah. Like it's a little outing. On the day of the hearing, following which Beata Kowalski wrote her suicide notes. Plaintiff claims that she was stripped naked in this process, but no such photographs exist. Thank Christ for that. And the two hospital employees deny that any such stripping took place.
Did he just say, wait a minute, what?
She was photographed in her bra and shorts. Plaintiff says she was stripped naked, but there's no photographs to prove she was naked. And the two hospital employees denied that it took place.
Yeah, because that makes sense.
Two different versions. Yeah. Like there's two different versions.
The coven, the seventh floor coven swears they didn't do it.
Mm-hmm. But assuming the truth of Maya Kowalski's recollections in this event, at almost 18, of events when she just turned 11, the event lasted a short period of time. It was only a short stripping. So see, they're assuming that her recollection is true. They're assuming she was stripped naked. Assuming she was stripped naked and held down on a table and photographed naked at 11. It was just a short period of time.
I am so angry at this. My blood pressure is rising. My head feels like it's going to explode. How are these people this evil, Jeff?
It was just a short essay. That's all. It's just a short period of time.
They are gaslighting her. They're basically saying, oh, all that trauma you suffered at our hands, it wasn't that bad. Grow up, Maya. That's
and see, this is assuming. This is assuming the truth of her recollection. God. Her recollection was stripped naked. Assuming, so in this we have to assume she was stripped naked. Assuming she was stripped naked, it didn't last. It was a short period of time. Plus Megan, she was on a hospital bed that in some of the pictures she has images of her stuffed animals with her.
Oh my God. What?
It was she was just stripped naked and photographed at 11 years old for a short period of time, and she had her stuffed animals. What's the big deal?
Oh my God. Oh my God. She
appears to be upset at this procedure, but there's no evidence in the photograph that she was struggling or that the two people whose hands are shown were doing more than simply holding her hands. I don't know, like this kind of doesn't look like someone who's just having their hands held.
Oh my God.
And she was clearly crying in the pictures.
How could they do this? How could they write this?
There's no evidence that she was tied to the bed or physically restrained by holding her head or feet or other parts of her body. She didn't report it to her psychologist that day or the family's lawyers. So the 11-year-old's going, I want to talk to my lawyer. Come on. Yeah, this is...
Right. That would happen. Right. Mm-hmm. She was probably so traumatized by it, she couldn't talk about it for a while. You know, I'm not sure who the first person is that she told. But, you know, I think it was her dad later. I think it was her father. Oh, my God. If I had told my father that, you wouldn't be able to stop. We would have a killdozer situation at that hospital. Mm-hmm. If that had happened to me and I told my dad, oh, God bless JHACH Kowalski for being the circumspect kind of guy he is. Yeah. God bless him, because my father would have he would have gone to jail.
I believe I did at one point in my life have to prevent my father from committing murder. For this lovely, charming new boyfriend of my older brother's ex-wife pouring boiling water on my nephew's feet as punishment for doing it. Yeah. I mean, literally, he was going to murder him.
Well, that would be justified in that case. My God, that's a horrible thing.
But yeah, I mean, just the fact that hospital wasn't burnt to the goddamn ground says a lot about JHACH.
I know. It says a lot about JHACH, because if I told my father this, I'm telling you, he'd go to prison. He would not care. He would do what he was going to do
Yep.
and turn himself in and go to prison. I know my dad.
That'd be me in the phone booth, waiting for him to walk by.
Yep. This is horrible.
And well, the evidence that it didn't happen, it's the manifest weight of the evidence is against the verdict and against the judgment. The defendant believes that under all the circumstances, photographing Maya Kawalski on January 6th was not unreasonable or unwarranted, but is not contending that it obtained the parents' express consent, or that a reasonable 10-year-old child could not find this conduct offensive. But, and thus a jury could conclude that this event was unreasonable and unwarranted. It requests a new trial on liability because of the evidence that the Kowalskis signed a release form allowing photographs.
Wait a minute, but it says unless a jury could find this unreasonable and unwarranted, which they did.
Thus a jury could conclude. The jury could conclude it was unreasonable and unwarranted, but they gave permission to allow photographs in the release form.
No. I talked to people about this afterwards because that stupid Dr. Perno said that once you sign the consent form, you consent to all of this. No, Dr. Corcoran said you can recall your consent at any moment. You don't consent to every single thing they're going to do to you. And if they're requiring that they have to strip you naked against your will and take pictures, you can rescind that consent. The patient has the right to say, oh, no, I don't want this. You don't sign a blanket consent for everything they want to do.
And the hospital's going to say, but that wasn't until after we did it.
These I'm sorry. I'm going to try and stop.
But for this false imprisonment in a hospital room for less than an hour, the jury awarded Maya Kowalski $188,000 for medical care and psychological expenses in the future, but there's no evidence that any such thing was ever even needed in the past. There's no evidence of any bodily injury. Okay, so if you don't leave a mark, that means you get to grape someone if it's just for a short period of time and there's some stuffed animals around. Is that what you mean? Is that what you mean, defense? Really?
That's pretty much what they are saying, yes. That's what they're saying.
There's no evidence of medical bills paid for such treatment, but the jury ignored the evidence and the instruction to address this claim on a separate claim, and it awarded Mr. Kowalski an additional $325,000 in past medical expenses. The jury awarded another $15 million in non-economic damages for this event! This is the third example of an award for pain and suffering this jury that exceeds the bounds of any reasonable range in which a jury could possibly operate. A verdict of 0.5% of this amount, or $75,000, would seem high, but be closer to a correct amount. And so they suggest the defendant submits that the maximum lawful range for future economic damages from this event would be less than $50,000. As to non-economic damages, the maximum lawful range for these damages for this event would be no more than $150,000. So 1% of the $15 million. Again, where is the clear and convincing evidence that all of this happened? The defense is entitled to a directed verdict. It was entitled to this relief from summary judgment, blah, blah, blah. They need a new trial as well. Motion for new trial on the amount of these punitive damages. The jury's combined award for the claim occurred simultaneously as $25 million, again, well in excess. This may be the most clear-cut example that this jury, under the leadership of juror number 1 and the arguments of plaintiff's counsel, overwhelmed the jury with improper passion and prejudice, and his belief that the defendant's employees had a specific intent to harm this child. The defendant is entitled to a new trial. Well, even if they think that the Kowalskis should be capped, not at the, what was it, 15 million? Was that what it was? 25 million. It shouldn't be $25 million. It should be 500,000. That's to me is the most disgusting argument in this whole thing right there. Megan, are you still with us?
I am here, but I'm in the bathroom where I don't have a great
signal,
so
just put okay.
I'm in the laundry room doing laundry, and there's no signal.
It just went radio silent there for a minute. So just checking. So battery. Let's talk about the battery. Where do they get the 1% explanation? Because that would be reasonable. Probably what they're saying is based on other similar cases, or just because it seems reasonable. That's their suggestion to the judge. Battery. This claim for January 6th, this claim involves evidence described in the preceding section, and the evidence will not be repeated here. That's the photographing stuff. The same statutory immunity that should have applied to false imprisonment should have applied to this claim, but the defendant's motion for summary judgment was denied, and it was not a factual issue for trial. Motion for a new trial on excessive compensatory damages. For the battery, the jury awarded Maya $4 million. Now, this is interesting. The defendant has not argued that the evidence concerning the claim for battery for this event entitles it to a directed verdict. They're saying, okay, we don't get a directed verdict on this one. Battery is a very technical tort. It's not really that technical. Battery is a very technical tort, and the defendant is not contending that a jury could not find the physical touching on January 6th was offensive conduct, even though it did not cause any apparent bodily injury. Bodily injury is not an
That's
element.
not battery. That's not. You don't have to be injured. It's unwanted touching. That's what it is in the state of Florida. I looked it up. It is being touched without consent. Is battery. You don't have to show an injury. You absolute retards. Are we allowed to say that word?
We are now. There's no evidence in the record that this event required medical treatment even in the past because they were awarded the $4 million for medical care and psychological expenses. Mr. Kowalski was awarded an additional $559,000. The jury awarded another $8 million in non-economic damages for this event. Again, this event did not involve any of the usual facts of battery where a person is struck by a fist or some weapon and sustains substantial bodily injury. This is the fourth example of an award which exceeds the bounds of any reasonable range. The court believed that the jury would understand this without a special directive on the verdict form, but the jurors clearly did not understand the task they were to perform. The jury clearly didn't understand. So a verdict of...
Yeah, because there were six people and they could not understand this because it's just too far above them. It's really too hard for them to understand. Oh my God, you guys.
A verdict of less than 0.5% of this amount, $25,000 would be closer to the correct amount. This is just another extreme example of a verdict where the jury was overwhelmed by passion and prejudice.
$25,000. Are they living in 1985 when $25,000 was money? $25,000. What?
And the compensatory damages. For the reduction of the claims, defendant submits the maximum lawful range for all damages combined from this event over and above the awards for false imprisonment would be less than $50,000. There's no evidence that this short event caused or was a substantial contributing factor to PTSD. Again, where's the clear and convincing evidence? Where's the clear and convincing evidence of intent? Where is the clear and convincing evidence that they were reckless? Motion for new trial. They want the damages reduced. And there we go. Battery for hugs and other touches. This is also interesting because it's kind of creepy. Maya Kawalski testified that in the chapel and at other times, Catherine, who have we learned who touches someone in the chapel? Maya Kawalski testified that in the chapel and at other times, Catherine Beatty gave her unwanted affection, including hugs and at least one kiss, and sat on her lap. She claimed other touches that were painful. Mrs. Beatty testified that she did sometimes give Maya Kawalski affection when she thought the child needed affection. People,
what are they insane?
Let's make a little flip here. Let's just change a name. Maya Kawalski testified that in the chapel and at other times, Doug Beatty gave her unwanted affection, including hugs and at least one kiss, and sat her on his lap. How would this have ended? They're just saying because it's a woman, it's okay. That's the vibes I'm getting from
that.
This
would never happen if it was reversed. Please excuse the music behind me.
Yeah.
I'm going to mute now.
Mrs. Beatty testified that she did sometimes give Maya Kawalski affection when she thought the child needed affection. There's no evidence that Ms. Beatty spanked this child for any reason. There's no evidence that she slapped her, whether for discipline or out of anger. Maya Kawalski, at least by today, clearly does not like Ms. Beatty. She was the bearer of bad news whenever there was bad news to deliver. That's why she doesn't like Ms. Beatty, because Ms. Beatty was the one that had to deliver all the bad news. It's understandable that a child would not like Ms. Beatty, even though Maya appeared to like many other members of the staff. Because Ms. Beatty was the one that told her she didn't get to go home for Thanksgiving. Ms. Beatty's the one that told her she didn't get home for Christmas. So that's why she hated Ms. Beatty, not because Ms. Beatty was a bad person, just because she was the bearer of bad news. There's no evidence that Maya Kawalski received any medical treatment in the past for these touches. Beatty's lucky she didn't have to receive medical attention after these touches. I'm so flustered and disgusted at this. She puts this little girl on her lap and touches her and hugs her and kisses her, but it's okay because she didn't need any medical treatment.
Disgusting. For
these alleged batteries, the jury awarded $19 million in compensatory damages to Maya Kawalski and $1,000 to her father. The compensatory award included $8 million for economic damages in the future and $11 million for non-economic damages.
Hey, wait, the chat just pointed out something really interesting.
What's that?
If Miss Beatty felt that the child was in distress, she could have called JHACH Kawalski at any time and put him on the phone with her or told him to come in and visit with her. Because JHACH was not under the constraints that Beata was. JHACH had unlimited supervised visitation in the first order. So, but they kept him away purposefully. She didn't need to comfort the child. She could have called the child's father to do that. And she didn't.
Mm-hmm. Could have. Well, again, the manifest weight of the evidence is against the decision, the judgment. It's the defendant's position that even Maya Kowalski's version of these events creates no question for a jury on whether a reasonable person would find these touches were offensive under like circumstances. That is the legal test for battery. The defendant realizes that reasonableness is typically a jury question, but the circumstances here involve a child who can't receive physical affection from one parent.
So we don't want the jury to be able to do that.
But the circumstances here involve a child who can't receive physical affection from one parent and only occasionally from her father or brother. The plaintiff claims that this child needed an advocate in the hospital. But when a trained social worker believed the child needed comforting, the plaintiff claims the act of affection or comfort was something that a reasonable person would find offensive. If someone else touches and gets all huggy with my kid, I'm going to fucking find that offensive. Respectfully.
Yeah, me too. Especially when they are her jailers and these are the people who took my kid from me. I don't want you touching my kid. Don't you dare touch my kid.
Respectfully, Megan. A reasonable person would find it offensive for a social worker not to give some affection to a child in this context.
What?
Yes, if she didn't give her hugs and kisses and put on her lap, you'd find that offensive.
No. I would say that was professional.
This is where I was saying change the gender of Beatty. Change the sex of Beatty. A female social worker placing a child on her lap when a child is upset does not rise to the level of battery. So it's okay because a woman did it.
Okay, so far this motion is ageist and now it's sexist.
According to the defendant, the defendant was entitled to a directed verdict. And between the two versions, because there's wildly disputed here. You know, the child has relived these events over and over in her mind, in part because her father's lawsuit required her to do that. There are different versions. Between these two versions, the weight of evidence does not support the plaintiff's claim. And a motion for a new trial. The jury awarded Kowalski $19 million. This is an amount that is currently near the outer limit of the award recognized in Florida for the worst sort of wrongful death claim. They can't even let Mr. Kowalski have $1,000 out of this. The compensatory award included $1,000 for Mr. Kowalski, which in the context of this verdict barely merits discussion, except for the fact that there's no evidence in the record to support the damage amount for these touches. They won't even give him $1,000 without arguing about it.
It's gross.
But the jurors clearly did not understand the task they were to perform on virtually all of the questions on both verdict forms.
Oh, really? They clearly didn't understand
just clearly.
not anything, Jeff. Nothing.
On both of the verdict forms, nothing. Virtually all the questions were just beyond their ken of understanding. A verdict on both economic and non-economic damages of less than 0.5% of this amount, $85,000, would still far exceed the range in which a jury was free to operate. So what do we think they should get? Defendant submits the maximum lawful range for future economic damages from this event would be less than $10,000. Non-economic damages, maximum lawful range, if they're not to duplicate earlier awards, would be less than $25,000. So 19 million plus however much, 35,000. Intentional infliction of emotional distress. Before we get to that, we need to clear off some of these super chats that have been building up for quite some time. I apologize for almost an hour for some of these. I feel really, really bad. I got emotionally involved here. It was passion and prejudice overwrought me.
You let your passions run away with you.
I did. Jojo became a YouTube member. Jojo, thank you so much for becoming the newest member. Deeply, deeply appreciate your support. Ike, thank you for another $5 super chat. These lawyers write this crap, and I bet they wonder why people think all lawyers are assholes. We take a lot of crap for
themselves. The jokes really write themselves when you read motions like this.
And unfortunately, like you say, people see really crappy stuff, just horrific stuff like this, and then they say, everybody's the same.
However, no, it's not true. But here's my theory. The best people and the worst people on earth are both lawyers. So when you find a really bad lawyer, they are horrific. But when you find a really good one, they'll save the world. They'll save your life. And I believe that Greg Anderson and his team, they're those kind of lawyers. These are lawyers who care about their clients, who are going to hell and back for them. So when you meet a good one, they're the best people on earth. It's just that lawyers also include the worst people on earth.
And you know how you can tell that, Megan? When you're looking at some of the arguments, particularly the closing arguments, the plaintiff's lawyers choked up, every one of them. Every one of them at some point choked up.
Yep.
What did the defense lawyers do? They laughed derisively. They smirked and laughed derisively during their closing arguments.
My sister, that you guys know, she's an attorney. She's a practicing attorney. She does trial work, appellate work. She's been in front of juries. When she saw that closing argument by Shapiro, she said multiple times, he's not going to like what he gets after this. If he doesn't stop that smirking and scoffing, he's not going to like what happens. And she was absolutely right. There's a way you do not treat juries. And
that was ugly.
He did everything wrong when it came to treating the way he treated that jury. And you can see the disdain dripping off of these motions about how little they had respect for this jury. They had zero.
And the judge and the parties. The only good people are Beatty and Smith. But again, it's clear the caliber of plaintiff's attorney, but the attorneys, because they choked up. This was emotional for them, and you just saw the disgusting behavior from the defense.
Greg Anderson and his wife sold their house so they can continue doing this case.
They had to downsize, yeah.
I mean, this is, when I tell you some of the best people in the world are attorneys, I mean it. But also some of the worst people in the world are attorneys. And there's just no getting around it. There's just, when they're very bad, they're very bad. And when they're very good, they're angels.
Becca B, thank you so much for your super chat. Should JHACH replace defense attorneys as they need better representation, or settle the verdict and start the healing process with the community? Well, I think they should, but they ain't going to. They're not going to. They clearly think that they've got a great team. Fun Diane, thank you so much. Basically, the first judge in JHACH said Beata could never be around her family, or Maya would continue to be held and tortured. What choice did she have? Now they don't want to take responsibility. Yeah, because it wasn't them, even though it kind of wasn't, for at least on 3 occasions. Yeah, Yeah, horse welfare. Thank you so much. And thank you to Dick Defense for showcasing how hospitals and their lawyers treat victims of medical malpractice and families of patients they unalive. They don't want to pay. Steve C. Is this normal in large cases? Appeal and lowball absolutely everything, or is this excessive even in Lawyerville? As I said, these are standard motions. This is something that is just almost routine.
But the language is excessive.
Yeah, it's the way they're doing it. It's the way they're going about it. Again, the same condescending, derisive language they're using. It sickens me. I know
that's it again. You go.
I know. I know. Because I used to do that just sort of as a tick, and people are like, well, stop it, and I stopped doing it. But it does
overwhelms you. You can't do anything but go. Ugh.
It's hyperbolic again, but it sickens me. It really does. It twists my stomach. I don't know how they can look in the mirror in the morning. I couldn't and write like this. Miles Strom, thank you so much for the $2. And Choosy Heretics Choose Carnation Revolution Now, new member. Thank you so much for joining the membership. And we're gonna have to split this up, Megan.
Yeah,
I've got about 10 more minutes. Yeah, I've got 10 more minutes. Then I am going to try to get 4 hours of sleep.
What do you think? Like tomorrow morning?
Well, I've got my regular Maritime Monday stream I have to do from, what is it? 11? 11 here. So it's 9 a.m. to 11 a.m. And then I can probably do a couple of hours after that.
Okay.
So from like 11 to 1.
That'll work.
Sense. Is that right?
Yeah.
Yeah. 11 to 1 Eastern. I can do that.
All right. Well, we could do it on my channel if you want, but we can talk about that later. We've got
a few more minutes here, so maybe we can get through the intentional infliction of emotional distress. This motion is giving me emotional distress. And it's intentional. They wrote this knowing it would cause.
I think we all have a claim now.
Yeah. In count 21C, Maya Kawalski claimed that the defendant's employees engaged in extreme and outrageous conduct with either the intent to cause her to suffer from severe emotional distress or with reckless disregard of the high probability of causing such severe stress. Well, the allegations are more or less a highly exaggerated version of the claims for false imprisonment and battery. Count 21C claims the defendant put her in a darkened room to torment the child, when the evidence from plaintiff's own experts is that sensitivity to light is on the BC of symptoms suggesting that a person may suffer from CPRS.
Oh, for fuck's sake!
They put her in the darkened room because they thought she might actually be suffering from CRPS, and they didn't want her to be light sensitive, even though they were trying to disprove. Really, Megan?
Bullshit. Let's go back to the text message that said she can't keep up the charade for 24 hours.
Well,
they called it a charade. So no, they were not concerned about the light sensitivity. Bullshit.
But they also claim that Maya Kawalski soiled herself in a room with constant video monitoring that shows no such event. And no such event was shown to the jury by the plaintiff. It claims the hospital placed a commode out of her reach as a torture technique, when the undisputed evidence established that she needed help reaching a toilet in any of her hospital rooms. That's the fucking point.
So what are they saying? That she did need the help to get to the toilet, or she didn't?
Yes.
They're saying she did. Well, that's
yes, and she didn't. And she didn't.
And she didn't.
Yeah, see, they didn't put it out of her reach as a test, because she always needed help to go to the restroom in the other rooms.
So they
that is so stupid
because she couldn't reach it anyway.
And yeah,
what?
Yeah,
okay, I guess
she had help in the other rooms, and so and they're like, oh, if we just put it right here next to her, then we won't be able to catch her using it by herself. So we're going to put it out of her reach to where she has no one there who can help her, so she'll have to do it on her own. That's the whole point, as I understood them putting it there. But now they're saying, well, no, it's always been out of reach and she always needs help. That's so stupid. It claims the hospital placed a commode out of her reach as a torture
It's very
technique.
contradictory. It's very contradictory to everything they argued in court.
One of the only videos the plaintiff actually showed to the jury involved a nurse helping her go to the bathroom. Well, that was the point. No nurse was going to help her until she had to get up on her own and use a commode that was out of her normal reach. That was the whole point of this test, I thought.
And I'm not sure that Maya testified that she had an accident in that room or if it was in her other rooms either. And anyway, anybody who would put that on a video for the public to see, I would have serious doubts about. Like, we don't need to see it. If that happened, and it may not have been video recorded either. So, because it might not have happened in that particular room because she was only in there for 48 hours. So they're suggesting, she wet herself. Well, how could they didn't play that video? Well, who would?
Yeah. So the plaintiff claims that a series of actions, many by Ms. Beatty, but many by other staff, were each contributing extreme and outrageous acts which made with the necessary intent to cause severe emotional distress. Well, I think that's the way it came across, even in the way that the defense was presenting these quote unquote tests. It was intended to cause her distress to where she would have to get up and do this stuff on her own without the help, and thereby prove she didn't have it.
Right. It was absolutely intending to cause distress, to break her from her act, to make her get up and
that
walk.
is literally how I read it, even from the evidence that was presented by the defense.
Yes. Yeah.
For this claim necessarily duplicated damages. For other torts, the court instructed the jury not to duplicate damages. Nevertheless, the jury awarded an additional $3.5 million past and future medical expenses and an additional $7.5 in non-economic damages. Well, again, the manifest weight, blah, blah, blah. It's the defense's position that while there may be evidence to support sufficient to support at least one false imprisonment, and even assuming that all of the intention, all right, I got ahead of myself, and even assuming that there were evidence allowing all of the intentional court claims to go to the jury, there's no evidence of acts individually or collectively rising to the level of extreme and outrageous conduct. Such conduct must be conduct beyond all reasonable bounds of decency.
That's like your opinion, man. That's your opinion. It wasn't the opinion of the jury. So
yep, such conduct must be conduct beyond all possible bounds of decency, conduct that is atrocious and utterly intolerable in a civilized community, and it must be committed with an intent to cause Maya Kawalski severe emotional distress or with reckless disregard of the high probability of causing such severe stress. And as Megan said, the jury said, yep, and I kind of agree with him. As a matter of law, neither the jury nor this court can engage in an act of alchemy that transmutes a collection of other acts by various employees this is offensive. This is an offensive paragraph. As a matter of law, neither the jury nor this court can engage in an act of alchemy that transmutes a collection of other acts by various employees that might be negligent, impolite, or rude into a pot of gold this jury awarded in the absence of actual evidence of extreme and outrageous conduct.
Come on. That's insulting.
This was just an alchemy to turn somebody being rude into a pot of gold. They're money grubbers. The Kowalskis are money grubbing people.
This contradicts what they said about them being a good family now, doesn't it? Just like I said. They didn't ever say the Kowalskis were a good family. They told us they were money grubbing liars and Munchausens.
And here's where they go after the court. The court knows it has a gatekeeping function for this tort. Before this court denies this motion, and this is the motion for the renewed motion for a directed verdict. So this is to say, okay, the defense wins. The prosecution, the jury said the prosecution won. I'd watched too many criminal trials. The plaintiffs won on this one. The jury ruled in favor of the plaintiffs, but we need a directed verdict from the judge saying just scratch that and rule in our favor. So before you completely throw out what the jury did and rule in favor of us, before you deny that motion, Before you deny that motion, the defendant requests the court to make a finding of fact as to the specific conduct that it believes is more than negligence and more than upsetting conduct. It moves that the court in any judgment include as a finding of fact its list of the acts of conduct that it believes were proven to the level such that the jury could find as a matter of disputed fact that the conduct was extreme and outrageous conduct performed with the intent.
So now they want the judge to make a list? Now it's the judge.
Yeah, this is like,
the judge homework.
Yeah. Before you deny our motion for a directed verdict in our favor, you put down, Judge, you list all these reasons why the jury verdict should stand. You do that. They're challenging the judge. If this court actually believes that there is evidence in the record of some collective strategy on the part of the defendant's employees to commit acts of extreme and outrageous conduct upon Maya Kawalski, acts that would be the predicate step to intentionally distressing her mother to cause her to commit suicide, this needs to be explained in this case of first impression. Accordingly, the defendant moves for a directed verdict on this claim because the evidence didn't create this claim. So yeah, they're basically saying, okay, Judge, if you're going to rule against us, you list out the reasons where you think we're wrong.
Is that a thing?
No, not really.
Making the judge do that? Is that like a thing? Like, here's your homework, Judge Carroll. Good luck.
There is evidence about religious materials which were kept out by DCF. Was it extreme and outrageous conduct to remove the woman with the 3-foot religious icon from the room when she did not register at the hospital entrance?
Yes. They threw Jesus in the dumpster and they kicked Mary out of the hospital. They kicked Our Lady out of the hospital. We don't want to talk about it anymore. It was outrageous.
They didn't mention that part. They just mentioned the woman with the 3-foot religious icon that didn't register at the hospital entrance. That's the only thing that had anything to do with religion, apparently.
They don't want to mention throwing in the dumpster.
No, they certainly don't want that. The manifest weight of the evidence may not establish perfection on the part of the staff, but it simply does not come close to supporting a verdict of liability for this claim. So we need a new trial because there was lots of prejudicial legal errors. Motion for new trial for excessive compensatory damages. The jury awarded $10.5 million on this claim. It awarded $3.5 million for past and future medical expenses. Even assuming that somewhere in this evidence there is a claim for intentional infliction of emotional distress, this award both for economic damages and for non-economic damages by this jury far exceeds the bounds of any reasonable range in which a jury could possibly operate. Once again, these jurors did not understand the task they were to perform for these questions on the verdict form. Those jurors, they're just not intelligent. Because of the duplication of any award of this claim would be near zero. That's what they're offering.
Yeah, that's what they're
zero.
saying. But no, I think the jury was really upset by that, by the prosecution.
Yeah.
No, there's no way a jury was going to say zero on that. They're out of their minds. That was one of the things. Did you see Steve Gosnell's reaction?
It's hard to hear you again.
Oh, shit.
There we go.
Did you see Steve Gosnell's reaction to finding out they threw Jesus in the dumpster? I mean,
nope.
And there was a Catholic on the jury pool. At least one. That was outrageous and extreme to us. So, just saying.
Well, defendant submits that the maximum lawful range for future economic damages from this event would be less than $40,000 after the offset of all other claims. As to the non-economic damages, maximum lawful range, $200,000. Tomorrow we can get into the medical negligence. How's that sound? We've got what do we so far we have medical negligence, and I don't think the billing fraud is particularly interesting or necessary. And then the estate of Beata Kowalski claims, and that's kind of it. This is a long motion, peeps.
Yeah, and I still got to find out what time this hearing is today.
Is it today or Monday?
Sorry, Monday.
It's got to be Monday. Yes, it's got to be Monday.
Today is Sunday.
Yeah.
Monday is coming. So I'm still trying to find out what time that's going to be. We don't know if it's going to be televised. However, there is a Zoom link. Judge Carroll's courtroom is on a public Zoom. So we'll be able to listen in, but I won't be able to broadcast that unless there are cameras in the courtroom, and then we can have the pool feed. So we'll see. It's all going to depend on what they're going to do.
And again, people, this long ass motion that we're reading, they're entitled to make whatever arguments they want to make and make whatever allegations they want to make, but they don't have to make them in the way they're making them. That's the part that's disgusting and cheap. They're going to go after our elderly expert again tomorrow, even more so than they went after him today. They talk about he hasn't practiced in this millennium. That's one of the other things they're going to say about him later. To literally make it sound like he hasn't practiced for 1,000 years. He hasn't practiced in this millennium.
Oh, that's really funny. That's actually really funny. I mean, do they know that we're all laughing at their motions? I bet that really pisses them off. By the way,
I hope so.
The Reddit page where Shapiro got all his information on so-called juror number one's misconduct, they are so funny over there right now. They are lamenting the fact that every law tuber has laughed at Shapiro's motion for a new trial. They're over there going, I don't think it's going to work. Every single law tuber says it's garbage.
Seriously?
Including the ones who think that it's not medical malpractice. So yeah, it's funny. They are just losing their shit over there. Like, it's not going to work.
I'm curious. I'm kind of curious to how old Hunter is. Because, like I said, he's not a spring chicken.
No, he looks like he's late 60s to me, maybe early 70s, but probably 65, 66. I believe he is he's known Greg Anderson for a long time. They've known each other. I think they may be peers. I think they may be in the same age range, but I don't know. I'm not sure.
Yeah. So, I mean, going through this, I said there was two purposes going through this. One was just to let you know what arguments are being made by the defense, and kind of just show you how these motions generally go. You want the judge just to go, okay, I'll give you the win, despite what the jury said. Like in the criminals here, that's like the judgment notwithstanding the verdict kind of a thing. They're basically saying, that we want the same thing here to go, okay, never mind. The jury was just totally off the range. They just went rogue. So, well, we'll just set aside their verdict and we'll give the defense the win. Everybody, every defendant wants that. And then if not, well, we want a new trial. And if we can't get the new trial, at least please, for the love of God, reduce the amount of money we have to pay. But so it's to kind of show you that and how these motions work. But it was also just, as we've said, to show you just how disgustingly some of these things can be written, how just unsavory you can be, and callous and careless and cruel you can even be in these motions.
It's totally uncalled for, but this is what I expect of the Dick defense. I expect nothing less.
Well, at least that the motion for a new trial due to jury misconduct, because it was about 50% annoying, 50% hilarious, and about 50% both. Do the math do the lawyer math on that one. But this one is just unsavory. It's just icky.
This one makes me feel inner rage. Yeah, it ignites my passions and my prejudice, JHACH.
There's very little funny about this.
Yeah, it's not good.
And Ariel asked, where can you find the motion on the clerk of court's website for Sarasota?
We're not sure.
When it gets
not there yet. It'll be there when it goes through the system, but it hasn't done that yet.
At some point on Monday, it should get there.
Yeah.
It's been filed. It just hasn't been posted online. Megan, thanks.
Thank you, Jeff. Thanks for doing this. Appreciate it.
We'll wrap it up tomorrow.
All right, sounds good.
And well, see, again, I mean, if the actual hearing is ongoing, then
right, we'll have to do that first, obviously.
yeah, so whatever that goes, and this might be a warm up to it. We'll just have to kind of see how things are going, see whether they're going to be streamed, broadcast, put on the
Right.
web, whatever, and make calls on the fly. But other what's coming up in Megan world these days as we wrap up?
Well, tomorrow I'll be doing either this with you or the hearing when it happens. So I don't know what time that will be, but if you guys follow me on Locals, meganfox.locals.com, I'll be posting where I will be and when, and we will continue following this shit show from JHACH.
And thank you for that, Megan, because you're shedding light on this and in a way that the average person sees it, not the way that us weird lawyers see things and issues.
I represent the six people at the bus stop, and I'm very proud of that.
Should we tell her she's only medium smart, so it's probably a short bus stop? Just kidding. And for me, Monday, which is Monday here now, so I guess I should say in about 17 hours, I'm going to get some sleep, going to go do a full day's work. Then I'm going to come home, and starting at 9 a.m. Eastern, I will be doing my normal. Every Monday, I do a Maritime Monday stream because that's my main focus of law is maritime and admiralty law. We do a Maritime Monday. We're going to be doing part 2 of the case of the sinking of the HMS Wager. Murder, mayhem, mutiny, cannibalism, all those things, as well as court-martials after everything was settled down. We'll be doing that tomorrow, part 2 of that. Tuesday, and again, immediately after that, we'll be doing this unless the trial the hearing is already going on. It's being broadcast. Tuesday is up in the air. We might be doing some YNW Melly murder trial updates. Megan just left us. I'm assuming she had a good reason to do that because she's actually doing stuff and we're just wrapping up. Yep. She sent a private message saying she's going to drop out. Thank you, Megan. We're going to wrap this up here in a couple seconds anyway. So Monday's Maritime Monday. Tuesday is probably going to be an update on the YNW Melly case. Wednesday is likely to be an Alec Murdoch update. And every Thursday we do an O.J. Simpson retrospective. We've been doing it for a little over a year. We're going to be starting on closing arguments, just reviewing the closing argument. And Friday, no idea yet. That's just kind of what's out there. It's all subject to change as this and other cases develop. But thank you so much for everyone that's here today. This was an impromptu stream that just came when we got this made available. We had to run with it because it's an exclusive. It's an exclusive Take Care of Maya update. And chat mods, thank you so much for being here. You mods are the best. Chat, thank you so much for being here. You are the greatest chat. The Vice Squad chat is the greatest chat on the entire internet. And anyone who's here for more than 15 seconds is an honorary member, or a default member, I guess I should say, of the Vice Squad, which you've named yourself. So please, on your way out, if you haven't hit the like button, I would deeply, deeply appreciate it. We're 4 away from 1,000 likes. Now we're 2 away from 1,000 likes. That's amazing. We've got over 1,000 people here. We had over 1,100 at one point. Thank you so much for that. And if you haven't subscribed, and if you have any interest in law-related things, trial and crew crime. Try that again. Trials and crew. I can't do it. It's because it's 3:00 in the morning, 3:30 in the morning. Trials and true crime. Do me a favor, subscribe to the channel, stick with us. We'll do this and other things as time goes by. I've got to get out of here. I need some sleep. Thank you all for being here. We'll pick up part 2 of this tomorrow. Until then, thank you, chat. Thank you for all the support with the super chats coming in. I think we got all those out of the way. Thank you for just being here and talking. Take care. Love you all. We'll see you. And until we see you again tomorrow for Maritime Monday and this part 2 of this motion, make sure you enjoy your legal vices. Bye. I forgot to hit the end.